May it please your lordships. Let the matter be listed for orders, my lord. This is a contempt case, my lord. The last date of posting was 5/3/2025. Next, I want 17/9/2025.
Take that from him.
Yes,
May it please your lordship. Lordship, with the consent of the other side, Lord, counsel for the petitioner lordship, I beg to mention item number 28, 29, 30 and 31. In fact, these matters were once heard at length and it was reserved for judgment. Now it came up. So may I prefer listing this matter after the vacation, lordship? 28, 29, 30 and 31. Vacation. This is consolation.
May I please?
I've taken consent from the counsel for the petitioner. Online.
I beg to mention
Okay.
for listing next Friday, my lord, 2 item are admission, next Friday. 19,
Admission
admission.
after vacation.
Some urgency is there, my lord. I have challenged, my lord, this DP.
Okay.
And my promotion is held up, my lord. Because of,
After vacation.
Maybe yes, I beg to mention
I am applying.
for listing and orders, Madam Lordship. For my pension has been stopped, Lordship. Family pension has been stopped, Lordship. Therefore, I have filed an IA, Lordship. So kindly take up next week, Lordship. My family pension has been stopped, Lordship.
After vacation.
Lordship, my family pension, I am suffering, Lordship. My
When?
since Lordship, petitioner has filed an petition, Lordship.
I am
date of suffering.
From 2 months, Lordship. From 2 months last.
after vacation.
May it please your lordship. I beg to mention item number 4, lordships. Lordships, this matter may please be taken up after vacation, lordship. Item 4.
So there being my minister also or
Hello.
May it be pleases you, Lordship. Taking concern of the other side, Your Lordship, I beg to mention item number 19 of daily list, Your Lordship. We have sent this affidavit for vetting, so kindly matter may post it after 1 week, Your Lordship.
of the other
Or
side. Of the other side.
yes, Your Lordship, concern has been made, Your Lordship.
Speed us. After vacation. Yes.
I'm deeply obliged.
Item number 25, I would like to mention.
Yes.
I'm not feeling well today. I have to visit doctor for checkup. I will inform the other council. And the matter be.
Yes.
Yes, sir.
After vacation.
After vacation or on 1st of October. 1st of October. That is on 20th of October. 23rd October. Highly obliged.
May I please, lordship. I would like to mention writ petition for listing, lordship. It was last listed on 28th of May.
Take any date from him after vacation.
Next week, lordship.
May I please,
Okay.
Your Lordship. With the concern of the other side, I beg to mention item number 36 and 37. Actually, Lordship, what has happened in the last order, Lordship, it has been stated that the matter, the justicial is the matter on 15th, my lord, on Monday. But matter has been listed on today, Lordship. I don't know why that's it. It should come on Monday, Lordship, on 15th May.
Next month.
Yes, Lordship. Because in the last order, it has been specifically stated that matter should come on 15th.
Your name, please.
Zedas, Lord.
Say the. Next Monday.
And then,
Lordship, I'm escorted on behalf of Mr. P.D. Nair in this matter, 36 and 30.
That's what number.
3 and 4.
I appear for the AG matter.
The fix of the number.
Number, I don't have the big type. AG, my lord, accountant general.
yeah, please, Lordship.
Highly
I beg to
obliged.
mention item number 6, Your Lordship. Matter may be urgent for the Your Lordship. 6.
The prayer being made by Mr.
R. Burman. On behalf of SD Roy. Respondent number 11.
R. Burman. Appearing on behalf of Mr. You are appearing on behalf of
SD Roy. Respondent number 11.
respondent number 11. Right. Consent from the other side, response is after petition.
Lordship.
Maybe pleases you lordship pertaining to item 19, your lordship, petitioner has objection, your lordship. Other respondent has given consent, your lordship. So your lordship, it may call for your lordship. Yes, your lordship. Deeply obliged.
May I please, Your Lordship, I beg to mention for listing of a matter, Your Lordship, for admission next week.
After petition.
Please, Lordship. Lordship, I beg to mention for listing up of a contempt case, Lordship. Lordship may kindly list the matter on any date next week. Next week, no one day. 25th. Obliged.
May please, your lordship. In this case, lordship, petitioner behind the bar near 4 months, lordship.
If
Oh.
it is accepted, let the petition come after some time.
My lord, in this matter, we have filed the affidavit yesterday, my lord.
I've got the copy, my lord. Though they have filed the affidavit, my lord, the guideline for of medical commission has not been annexed. And with regard to list, my lord, the merit it has been finalized. I have
Let the affidavit come.
yes, lordship, may I submit, my lord. But I take
The affidavit is not available on the record.
then it will be called for, my lord. It will be taken after some time. Because the medical admission is
Or, my lord, I have a copy. In the meantime, they may call for and your lordship may go through this, my lord. Yes.
Yes. What is your stand in your affidavit?
My lord, my affidavit, my lord, we have annexed the notice at page 44. My lord, by which notice, my lord, educational notice, my lord, the last date was fixed on 11th of July 2025 as the cutoff date for submission of application for change of category, my lord. At page 44, clause 1, your lordship will find candidates who want to change their category can now apply in a prescribed format, which will be available in the official website of the Directorate to ensure from 5th July 2025, along with the supporting documents to the office of the undersigned on or before 11 July 2025 during office hours by hand. No further application will be considered by this office after the last date of submission. Application sent via so shall not be accepted. And they have alleged that one candidate has been allowed to change his category, and that candidate, my lord, submitted his application prior to the cutoff date. Annexure 45 is his application, my lord. He submitted his application on 10/7/2025, and accordingly, he was allowed to change his category, my lord. And now, my lord, the merit list was published, my lord, after that date, my lord. So, merit list was published. On the basis of the merit list, first round of counseling has been completed, and admission has been done, my lord. Now, my lord, after first round, after publication of the merit list, after first round of admission, my lord, the petitioner cannot be allowed to change his category because the category wise, reservation wise, the merit list has been prepared. And apart from that, there are other around 20-25 applications has been filed, my lord, praying for changing the category. And those applications have also not been considered by the department. Because now at this stage, it cannot be done. If the petitioner is allowed to change his category, the entire election process, admission process has to start afresh, my lord, by publishing the new merit list, new admission process. Everything has to start from the beginning, my lord. So at this stage, after cutoff date, my lord, he cannot be allowed to change his category. And this notice specifically mentions it. If he could not submit within this stipulated time as per this notice, now he is not entitled for change of his category, my lord.
First round of counseling complete.
Counseling completed, admission is completed. After this educational notice, after consideration of the application which has received at the page 45, my lord, that candidate was allowed to change his category. After that, merit list was finalized, published. Now it cannot start afresh, my lord.
Any other point?
Yes, my lord. That
There are points. The process.
Yes, Lordship. I take your Lordship to the,
So if the petition is allowed, then the admission process has started fresh.
yes, my lord. In my affidavit.
First round of counseling completed.
Yes, yes,
Then merit list was finalized.
yes, my lord. In paragraph 10, my lord, page 42, I have stated, my lord.
I take your Lordship to the judgment I have given. Monupatra judgment, Supreme Court of India, my lord. Paragraph 31. Has your Lordship got it? Paragraph 31, my lord. I have marked it. There is no doubt that 30th September is the cutoff date. The authorities cannot grant admission beyond the cutoff date, which is specifically postulated. But there is no fault. But where no fault is attributed to a candidate, and she is denied admission for arbitrary reasons, should the cutoff date be permitted to operate as a bar to admission to such students, particularly when it would result in complete ruining of the professional career of a meritorious candidate? Is the question, is the,
Here, who is responsible for failing to apply within the?
I'm not responsible, my lord.
Who is responsible?
Authorities,
Published earlier, fixing the cutoff date.
no, this is not the cutoff date. I'm coming to that. my lord. Cutoff date means the cutoff date of the admission, not the procurement of the degree, the certificate. Cutoff date is that cutoff date. Cutoff date, my lord.
Cutoff date for receiving application.
Yes, ma'am.
No, my lord. Cutoff date is the specified by the Honorable Supreme Court, my lord, 30th September. 30th September is the cutoff date for admission. And that is the parameter. That has to be followed. And what my learned friend has submitted, this is not the cutoff. It cannot be treated as a cutoff date. Cutoff,
Why?
because my lord is there. It is not specified in the rule. Once it is not specified in the MCI rule, my lord, as well in the state rule, my lord, it cannot be. It is Honorable Supreme Court has specified what is cutoff date, my lord. That I am reading, my lord, this judgment. Cutoff date cannot be determined by the notification issued by the education DME, my lord.
Where it is stated?
Yes, madam, I'm coming, my lord. Let me just read the paragraph, my lord.
No, well, you are not required to read entire paragraph. You point out it where it is.
Yes, lordship, this is the paragraph. This is on basis of the cutoff date, my lord. The students, unless I read it, your lordship, it cannot be clarified. Candidate And she is denied admission, similar circumstances, my lord. Denied admission for arbitrary reasons. Should the cutoff date be permitted to operate as a bar to admission to such students, particularly when it would result in complete ruining of the professional career of a meritorious candidate? Is the question we have to answer. Having recorded that the appellant is not at fault and she pursued her rights and remedies as expeditiously as possible, we are of the considered view that the cutoff date cannot be used as a technical instrument or tool to deny admission to a meritorious students. The rule of merit stands completely defeated in the facts of the present case. The appellant was the candidate.
Okay, if your submission is entirely based upon this judgment,
Yes.
so Farah, you please go through it.
My lord, this is, I know the judgment. This is with regard to the cutoff date for admission, my lord. But the criteria, eligibility criteria, it is in respect of eligibility criteria. That is in respect of merit and cutoff date. That is a different. That is in a different context, my lord.
Eventually, please go through the judgment.
Yes, my
You
lord.
point it out to this court as to whether it can be applied.
Yes, my lord.
After we will take it out.
After some time, my lord. Yes, my lord.
Football. Very good point. Well, I have been informed that my case has been recommended by the DLC just now.
Oh, it is.
Yes. Yeah, oh, I'll do good.
Now it has to be plus protocol.
Yes, ma'am. Okay. Okay. Yes. All right. Fine.
Page 10, well, page 10. Serial number? Mrityunjay, top of our month. Serial number 2. Then, there we are disposing of this.
Yes.
Let the matter to
Yes,
judge.
yes.
Wait, please, my lord. Matter pertains to compassionate appointment. Prayer for placing before the SLC, similar to the last. To challenge the OM 24. Previously, my lord, DLC, my matter was placed, my lord, pursuant to the honorable court's order, my lord. It pleases my lord.
Page 28, your lordship. Page 28.
28.
Page 28, serial number 14. Present placed in the DLC meeting, complying Honorable's Guwahati High Court order dated such and such, passed in such and decided to recommend and refer to SLC for further consideration as it's seen that the petitioner is over age at present. So it was held on 1/9/2023. So let her try her luck in that. Yeah.
I'm deeply obliged, my lord. But, this is not a fit case. No. This is not a fit case for referral.
Mediation.
Malad,
Will fix the matter for additional hearing.
yes, ma'am.
Or they have data for respondent number.
Elementary education.
Okay. Elementary or with contact for the additional subject, that is not a big case. For referring to the mediation, those are matters that are not for. Accordingly, it is provided that it comes up for additional hearing immediately after reopening the vacation.
Malad, do you have a try before vacation? Before vacation, can we have a try, Malad?
Not
On
possible.
24th?
Lot of matters are
No, only thing, my lord, on 25th, the similar matter is there. Your lordship has fixed, my lord. In a contempt proceeding, this is a writ. That is on 25th. That is on 25th.
take it that from immediately after the vacation.
Immediately after vacation. Okay.
Take it that from
Okay. Deeply obliged.
Please, Your Lordship. I'm appearing on behalf of Mr. R.A. Chaudhary, Lordship. R.A. Chaudhary.
Medical যাবো নি তো pension matter. This matter relates.
Can I refer the matter to the vacation?
No, Lordship.
No.
No, Lord.
Dispute between first and second wife, no, dispute between two wives who would get the pension higher. Can be sent for referral.
No, Lordship, as per last order, Your Lordship, it was referred that the matter may not be referred to mediation. Last order, Your Lordship, that is on 5/8.
So will then why the matter is listed again under the same column? There is already a decision of this court not to refer the matter to the magistrate.
Then how?
Your Lordship may kindly peruse the order, Lordship.
5/8/2025.
I was just indicating, my lord. Actually, I have nothing to do with the matter. Office has got nothing to do because the person concerned was a provincialized teacher. And so far as provincialized employees are concerned, office of the AG does not deal with pension benefits of those employees. The pension and public grievances department would be dealing. Just a formal.
Your good name, please.
Miss R.A. Chaudhary.
R.A. Your name.
Yes, R.A. Chaudhary. I'm appearing on behalf of R.A. Chaudhary.
Your name, please.
She is also R.A. Chaudhary.
My name is also R.A. Chaudhary.
Miss R.A. Chaudhary on behalf of
Yes,
Mr. R.A.
Mr. R.A. Chaudhary.
It's R.A. So hard that
M.H. Roscoe. M.H. 9. Private.
the piece of code number
5.
5. Data code number. Every code number.
Elementary. Video report here.
I'll put respondent number 2.
Number 2. Then follow up
1, 3, and 4.
Miss Purva.
Finance. Flow 1, 4.
Finance.
I'm 1,
3 and 4.
I am 1, 3, and 4.
to the method is listed under the column.
Treasury officer, respondent number 8.
And public to the that is important for referring to the method. And accordingly, provided that is the metaphor and it is the open.
My lord, the pension proposal, my lord, with effect from 2001 has been already forwarded to the director pension, my lord. So, my lord, let us wait for few days more, my lord. It is before the director pension, my lord.
ভাল হে
Yes.
মিডিয়েশনত জলদি হ'ব পাৰে মিডিয়েশনত জলদি হ'ব
After few days, my lord, it will probably it will be settled. After few days, it will be settled, my lord, because the proposal was sent on 22/6/2025, my lord.
And number two side होगा second
For respondent number
it one of the
5,
one
Five.
correspondence six no
I mean,
আমাৰ ফুটুৱা হৈ গৈছে এটা মই ৰাখিলো আৰু
Better is being processed.
oh, the
Week. 2 weeks or few days.
my lord. Well, director pension, well, he is present, my lord. He will get the update, my lord.
already from our end your lordship it was submitted now your lordship director of pension is going to give the status report up to date status report
That is come after.
I'm appearing for
Cycle.
1 3 and 4
Try to obtain the necessary.
After
2 weeks, your lord.
4 weeks.
2 weeks, two.
After
4 weeks yes
after 2 weeks.
one long.
It's
one long.
Director of pension. Check. Obtain up to date status about the status of the file. File of the pension.
My lord, during pendency, my lord, shall not be barred to the days of pension, my lord. Otherwise, my lord, they will what, my lord.
That is the
Here, bro.
releasing the pensionary benefit.
Might.
DP of
Amablet.
this.
May it please. But this matter has become infectious because he has obtained the pension, my lord. Petitioner has already received the pension. Pension, yes, my lord. Matter has become infectious.
Or are
For respondent number 4.
Or by the state of the court. That depends on the yes, also
Masterlies.
Lordship, Honorable Court order dated 9/12/2024, Lordship. I have appeared before the Inspector of School, Lordship, Deputy Inspector of School, Lordship, and my statement has been recorded, Lordship, and the excess of hard royal amount has been held up, Lordship. Even Honorable Court has stayed up previous dated, Lordship.
how what is the
So, Lordship, presently, Lordship, matter has been, amount has not been deducted, only interference of this honorable court order. But the fact is that, your Lordship, only during the pendency of this case, Lordship, my provisional pension or either final pension has not been released as on today, Lordship. So, Lordship, it is well settled law there about that the coordinate bench of this honorable High Court, as well as the Supreme Court of Robik Machi, Lordship, the excess of hardware amount cannot be deducted or either target or forget employee. Lordship, matter may can be disposed of at this stage.
order?
Matter may can be disposed of as yes, Lord. It is very much clear about the Supreme Court, Lordship, Robik Machi, 2015 SCC, Lordship. The excess of hardware amount, your Lordship. Annexa page number 20, your Lord. That is the calculation. drawn by the Deputy Inspector of School, 11 page number 23, Lordship. That is,
Yes, Your Lordship. There is an office memorandum of the government on this one regarding deduction of overdraft amount. So why your department has been flouting that document?
Yes, that is the issue, has been before your lordship. On one occasion, uh, I pleaded before your lordship that why, in spite of existing of that particular office member, why they are, so with appropriate, your lordship, maybe in next week, with appropriate reason, that means, that why it is done repeatedly. So I shall try to write. And lordship may give me an, if your lordship pleases, give me a handle so that through orders I can furnish it. Because in spite of existence of that is leading to many litigations, your lordship. In grade 3 and grade 4 employees, definitely the Supreme Court has barred.
They have been compelled to approach this court.
Yes, your lordship. Yes, your lordship. So some,
Why should we not impose some cost upon the person responsible for it?
Lord, one occasion, your lordship, because what may be the background that um, due to the background, because the Supreme Court judgment says that if there is not a mistake on behalf of, so what led to the circumstance that matters a lot. So on that backdrop, let me obtain the specific instruction. By next week, I shall be, lordship may make an observation. I shall, on basis of that, I'll try.
but Lordship, very interestingly, my provisional pension has been held up only because of that, the pendency of this present lead petition, Lordship. It is very unfortunate, your Lordship.
So how can I stop the provision?
Provisional pension is by the department, your lordship. It is not by us. It is by department.
Madam, some timing we are allowed to pay the provisional pension, madam.
So you obtain instruction then why this provisional pension has not been released?
Okay.
Because of it.
Yes, madam. I mean, we are allowed to take instruction why the provisional pension has not been released.
So we are not closing the petition today.
Yes, your Lordship. But Lordship, one line may can be added, pendency of the present lead petition shall not be barred to the disbursement of the provisional pension. Benefit.
Part,
Okay. No, South Shore, ma'am.
what part? Okay. Eliminated part. That's the day
For 2, 3 and 4.
for 3.
2, 3 and 4.
Number 20.
20.
So yeah, learned for the petition or something.
Oh, बिल्कुल इसे बिल्कुल.
Of the interim order passed by this court.
Two,
On 9, 12, 20,
1,
20, respondent
5,
have not recovered the amount from the pension and pensionary benefit of the petition. But unfortunately, the respondent offer is have some payment of provisional pension and other benefits. According, it is provided that number they have obtained
1, 5, and 6.
why the has not been paid. Further, Sir David, current standing council product is directed for why the offer numbers are sorting recovery of the excess trial, over trial amount of salary. In spite of existence of one of by next, this is the base commitment on probation.
Tendency of this petition shall not be barred to release any that one.
The tendency of this not be a part in releasing the some provisional pension or regular pension.
Provisional
Provisional
yet to be released.
pension.
Deeply obliged.
So this is pension matter that can be settled. But the problem is that lordship, they are not appearing. In another case, lordship, I inform the client, my client had come, but they are not appearing in pension matter. I don't know whether this they will appear or not. If your lordship refer this matter to mediation. If they appear, lordship, then family pension, lordship, unmarried.
So, yeah,
My lord.
elementary director.
They are lordship.
In this case. Who has paid?
Respondent will pay for it.
So there are many respondents.
Yes, lordship. Basically, lordship, director of pension and
Director of pension is not a yes.
Number 6.
number 6.
So
Pension
there is
Yes, your lordship.
and director of 5, 6, 7.
so earlier one matter was referred to the mediation.
Yes.
And no one from the respondent in respondent number 6 and 7.
Well, this matter, not this matter, another matter, lordship, my matter, lordship.
Yes.
That was referred to mediation. I inform my client have come, but they are not appearing. Similar.
Whether proper steps were taken to them or not, it was brought before their notice or not on that, on particular such and such their mediation is there, your lordship.
Why it is that it's not. We have directed you to appear to remain present for the mediation. Order was passed in presence of both the parties. It is your duty to communicate to the respondent. Why it is a special text that
That part, we have to see, your lordship, because
do we refer this matter to the mediation or not?
lordship, it's a matter relating to the, if I can have the instruction, your lordship, because matter relates to unmarried daughter pension, your lordship. So, if as usual course, if I obtain the instruction, that will perhaps more serve the purpose.
So during pendency, some benefit has already been released regarding lordship GPF amount, gratuity, leave encashment has received.
And lordship,
Pension.
lordship, we have one instruction, your lordship, already, which they need to submit the required relevant documents, which has not been yet, your lordship. On way back in May, it was informed to them. May
I have submitted.
তেতিয়াহ'লে পাব মই আপ টু ডেট ইনষ্ট্ৰাকশ্যন লৈ ল'ব
Third F1 learner. The murder set for respondent number.
My lord, respondent number 7, my lord, accountant general.
Every for respondent number 6.
6 2 and 6
6. And it's for respondent number
1, 7, 7,
1 and 5.
1, 5, and 7.
4 and 8.
1, 5, 7. Forward for 3 and 8. It's forward for. Okay.
My lord, I made a mistake. My lord, I'm for 4, respondent 4.
Okay.
Take a look.
Mr. Khan learned counsel for the petitioner applies for debt during the pendency of the pensionary benefit has been released by the respondent authority. And though the matter is listed under the column number Mr. Khan submits that this measure cannot be referred to the mediation. Not be referred to the yes. In connection with another date petition which was referred to the mediation, the respondent authority never entered appearance before the mediation, though the petitioner remained present on the date fixed. So Terry learned from the respondent authority that orders contain instruction to this court. And some extent, the director of pension has written a letter to the district elementary of the sum for submitting the unmarried daughter pension proposal. For submitting the unmarried daughter pension proposal in respect of the present petitioner, along with duly filled up forms and relevant documents, the director for further. So Terry, this letter was written on 26th of May 2025.
Yes.
So what is the progress?
Now, present status, your lordship, that your lordship may give me 1 week time, or next week it may be listed.
However, Mr. Terry submits that we got it 1 week time to obtain up to date instruction with respect to the letter dated 26th of May 2025 written by the director of pension, the district election officers. Accordingly, it is provided that there is a list of
My lord, can I make a submission, my lord? The lordship has mentioned that in a previous matter, it was referred to mediation and people have not gone. But here I am, AG is also a party. The moment this order goes, my lord, there will be an inquiry as to what is what, my lord. Your lordship may kindly, your lordship will say that ensure that the parties are present. That statement may not
no,
be.
today we are not referring to this matter, we are not referring to the mediation.
But then I do not even know which matter. If he,
I can give the number.
he can give the
That
number.
that was fixed on last Monday, Lordship.
Let us reflect
I
in
am
the
giving-
order sheet, you give the number.
Yes,
Yes, Lordship.
then we will oblige.
I am giving, Lordship. Oblige. May I please, Lordship? Petition, in this case, petitioner behind the bar near 4 months, Lordship. Sections are, Lordship, 75(1) and 75(2) of BNS, which are maximum punishment is 3 years. And also POCSO 8, which is maximum punishment is 5 years, Lordship. So, petitioner paying for regular bail, Lordship. FIR at page 15, Lordship.
At this stage, Lordship, notice may go, Lordship.
Case is registered under section
Section 127 2, 75(1), 75(2) BNS and section 8 of POCSO Act. Lord.
also is there.
POCSO is here, section 8 is here, Lordship.
Then take state.
Lordship. Short date may be given, Lordship.
Mr. APT Sarkar, learning APT Hawk,
Lord.
Hawk, learning. Thus, learning. Applicant for Banka Das, who has been like or others 127 of BNS lead to second of the POXO Act for special session special list of the different by that the F1 here the fire long one
Petition.
fire long one Potmo Dekat Potmo or Potma
Podma Deka Takurial.
Potma Dekat that notice be issued to the having heard the submission of the verdict that notice be to the comment the office of the public prosecutor Guwahati High is that the learning that is not it shall update before the effect of service of notice of the just on the number two is the method after one
On 24th September, Lordship.
Obliging.
Please, your lordship, my lord, I have gone for the judgment, my lord. It is in a different context. The candidate therein, my lord, initially she was admitted in the BDS course as per merit. As per merit in the first the round of counseling, she was not entitled for MBBS seat, so she was admitted in BDS seat. Subsequently, in the second round of counseling also she appeared, but the authorities found that at the time of calling, when she was called, she was not present there, she was absent. And subsequently, some candidates below her was admitted to MBBS course. So as per merit, she was entitled for MBBS course in the second round of counseling. But since she was not present at the time of calling her roll number, so the persons below her were admitted in the MBBS court. Accordingly, she approached the Honorable Court. The single judge, my lord, passed a order, my lord. Single judge, allowing her to take admission, my lord. So there was an appeal. Appeal was against her. Again, she approached the Honorable Supreme Court, my lord. The fact is that, my lord, so subsequently, my lord, the issue came before the Honorable Supreme Court was that because already earlier, my lord, the Supreme Court has fixed the 30th September as the last cutoff date for admission into MBBS courses. So that was the cutoff date because Supreme Court held that after 30th September, at any rate, no admission should be given to the MBBS course. But in this case, the issue was that the candidate claimed that she was present in the counseling process, second round of counseling process. But authorities contended that when she was called, my lord, she was not present, my lord. So that was the dispute. But otherwise, as per merit, she was entitled because only because she was not called, she was not present when she was called. So authorities admitted some students below her, my lord. So ultimately, those records were scrutinized by the appellate court as well as Supreme Court, my lord. All the relevant records were produced, wherein it was found that she put her signature, her attendance was also taken during the second round of counseling. So then, my lord, that question arises where she could be admitted after the cutoff date or not, my lord. After the cutoff date of cutoff date fixed by the Supreme Court for admission into MBBS course, my lord. And otherwise, my lord, some of the observations is in our favor also, my lord. If your lordship takes, comes to paragraph 24 of the judgment, my lord. Paragraph 24. I will point out some relevant paragraphs, my lord. Paragraph 24.
Yes.
Paragraph 24 says, adherence to the schedule is the obligation of the authorities and the students both. So schedule, my lord, whatever schedule is fixed by the authorities, my lord, that has to be adhered by both the authorities. So here, my lord, the schedule was that within this time you have to file an application for change of category. So it has to be applied, my lord. Adherence to the schedule is the obligation of the authorities and the students both. The prescribed schedule is to be maintained stricto sensu by all the stakeholders, because if one party adheres to the schedule and others do not, or there is some kind of lack of communication or omission to make proper announcements and maintain proper records for such counseling, distress results can follow, of which the present case is an apt example. Then, my lord, paragraph 26, my lord. Strict adherence to the time schedule has again been a matter of controversy before the courts. The courts have consistently taken the view that the schedule is sacrosanct like the rule of merit, and all the stakeholders, including the concerned authorities, should adhere to it and should in no circumstances permit its violation. This, in our opinion, gives rise to dual problem. Firstly, it jeopardizes the interest and future of the student. Secondly, which is more serious, is that such action would be expressly in violation of the orders of the court and therefore would in so and so, so and so. Then, my lord, paragraph 29, my lord. In the prospectus issued by the respondent, chapter 9 deal with the method of selection and admission. Clause 3.1 stated that it was mandatory for the qualified candidates to appear before the counseling board in person. No relaxation was to be given to the candidates who were unable to appear before the counseling board on the fixed date. So, my lord, it is similarly, my lord, no relaxation can be granted to any candidate who could not file their application for change of category in due time, my lord. So it has been held, my lord. Then, my lord, what is the main issue that paragraph 30, my lord, your lordship will find? All these clauses are in accordance with the regulations framed by the Medical Council of India or the notification issued by the concerned state government. Relaxation of the rule of merit for reason of non-appearance is not permissible. In the present case, there is no dispute that the appellant was present. So there is no dispute that the appellant was present at the place and on the date of second counseling. But the dispute relates to her absence at the particular time when her name was called out for the purpose of counseling. As far as this issue is concerned, we have already expressed the opinion that there is no substance in the defense taken by the respondents and the appellant should be entitled to the relief prayed for. However, the question that immediately follows is whether any midterm admission can be granted after 30th September of the concerned academic year, that being the last date of admission, date for admission. So the issue is that only, my lord. Because dispute is there, she was present in the counseling, second round of counseling, and authorities was saying that she was absent while her name was called for. But the records otherwise said that she has put her signature, her attendance was taken. So after that, when court came to a finding that she was present and she can be given a seat, my lord, then issue came whether she can be allowed after 30th September or not. That is the main issue, my lord. So on that count only, this judgment has been passed, my lord. Then your lordship may peruse paragraph 31, that is also relevant, my lord. There is no doubt that 30th September is the cutoff date. The authorities cannot grant admission beyond the cutoff date, which is specifically postulated. But where no fault is attributable to a candidate and she is denied admission for arbitrary reasons, should the cutoff date be permitted to operate as a bar to admission to such students, particularly when it would result in complete ruining of the professional career of a meritorious candidate, is the question we have to answer. Having recorded the appellant is not at fault and she pursued her rights and remedies expeditiously as possible, We are of the considered view that the cutoff date cannot be used as a technical instrument or tool to deny admission to a meritorious student. So your lordship has now find that what was the issue here. That is the issue. That issue is not the issue that is with the petitioner. Because she fulfilled all the schedule. And fault was of the respondent authorities because her attendance was recorded, she put her signature, and thereafter it was contended by the respondent authorities that she was not present in the counseling process. So in that context only, that was judgment has been passed, my lord. But otherwise, the candidate have to follow the schedule formulated by the authority, the date of submission of application or anything. So here, that 11 July was the last date of submission of application for change of categories, which the petitioner has not complied with, my lord. In this case, my lord, the petitioner complied with all the schedule and all the requirements, but here the petitioner has not complied, my lord. So the petitioner is not entitled to change his category, my lord.
May I submit, my lord?
Yes.
My lord, it is a settled principle that, my lord, when the law prescribes certain things has to be done in a certain manner, it has to be done in that manner only. Here the law, my lord, with regard to the admission is rules of 2017, as well as the MCI rule, my lord, National Medical Commission's rule, my lord. That does not, neither of the state rule nor the central rule, my lord, does not, my lord, make any cutoff date to be provided for change of category. This is my number one submission. Secondly, my learned friend all along has stated that the list has been finalized. It is, I humbly submit that, my lord, as on date, list is not finalized. The process of finalization is given in the rule itself. After the approval of the, my lord, selection board, it has to be given to the government and there has to be notification. Unless notification is issued, the list is not finalized.
No, that's all right. That is not provided in the rule.
Yes.
Regarding the cutoff date.
Yes.
But the question is after the process is over, can it be
Process is not over. Process means what process, my lord? Process means the process of admission. The last date of second counseling is up to 19th of September. Honorable Apex Court has.
No. Question is not in respect of admission here.
Application.
Question is only filing the application.
Yes, that I'm also submitting, my lord. And let me complete my submit and then you will find. They have the rule prescribes for, my lord, on the date of submissions, one must be present with all documents. That is on the date of counseling. On the date of as per the rule, on the date of counseling, one candidate must be present before the selection board with all documents, or in original as well as in duplicate self-attested copies. This is the rule. And, my lord, the categories, the list which they have published, and all are provisional list. Then not a single list is final list. Second submission, my lord. And my lord, the petitioner before the cutoff date specified by the Honorable Supreme Court, as well as the cutoff date specified by the National Medical Commission, my lord, the petitioner has procured all the documents to appear before the second counseling. The question of change of category would not arise prior to that. Yes, because their online portal application has also been, my lord, I have placed before your lordship the application accepted by them, and the seat locking has been done. I have given, my lord, in the name of the petitioner, seat locking has also been permitted against OBC NCL code category in the online portal. This is because as per rule, I have given the extra schedule, my lord. This is permitted. Against the name of the petitioner, online system has accepted the seat locking, preference locking, my lord. It is accepted, and against OBC NCL category. We are not concerned with the candidates who have been appointed in the first category, my lord, for first round of counseling. We are not against them, my lord. we are only with respect to the seats at present lying vacant. Therefore, those who have been admitted, we have no grievance against them. And the list has not been finalized as on today, my lord. What is the bar, my lord, legal bar? There is no ambiguity in the legal provision. The law is clear, expressly, my lord, it says that on the day of counseling, the candidate must be present before the selection board with original documents in with all original documents and, my lord, self-attested certificate copies. The online portal also accepts the, my lord, the application of counseling against the respective quota of the petitioner. And locking is also permitted. The Honorable Apex Court has laid down, in my learned friend has not read the relevant paragraph after the 31 that I am reading, my lord, paragraph 31. Again, I will read from the judgment, paragraph 31. What is the sole purpose of this system? What is the sole purpose of this admission? What is the main motto, my lord? It is to give the rule of merit. Had I been lower in rank than the candidates who have been appointed in the first counseling, I would not have come before this honorable court, my lord. I have secured more marks than the candidates who had been admitted. Then, therefore, I have come before this honorable court.
Cannot argue on that point. Cannot argue.
And the law is clear, my lord. Statute is clear.
Tell me which provision is clear?
Yes, lordship. 5C.
5C of,
The rules, my lord, 2017 rule.
is it part of the record?
Yes, I have given the extra copies of the rule, my lord. Medical rule, I have given the.
Not available. Rule?
5C, my lord. Let me read from 5A. The candidates, the candidates who are called for counseling must be physically present before the selection board. They must submit the duly signed and completed application form along with all the relevant certificates and annexes, which must be signed by all the concerned authorities officers as noted and instructed in annexes. They must bring all original documents like admit card of NEET, admit card and pass certificate of HSLC or equivalent examination, mark sheet and pass certificate of HSLC or equivalent examination.
Whether there is any provision for signs of this category? Yeah.
No, that's why I am saying submitting, my lord. Their question does not arise. This is an extra administrative exercise done. That is my submission, my lord. That is not at all required by the DMA to issue certificate for change of category. It is the date on which the counseling is done. It has to be determined. The category of the candidate, not prior to that.
Is it the proposition of law that you have applied in a particular category and can be admitted in another
Yes.
category?
Yes.
No.
No. That is not that is not that.
Then-
I have applied for OBC NCL in the second round of counseling. My applications has been accepted. Seats have been locked against my name, against that particular category. Now, on the day of determination of my allotment of seat, the question of the category will come. Not prior to that. The rule also says like that. Therefore, I have submitted. When the rule says something has to be done in a particular manner, the authorities cannot deviate.
No, it is provided.
It is not provided. That is, I am submitting, my lord. They have done it without having any authority. They have done it without having any authority. That is my submission on the basis of the rule. Therefore, the question of cut-off date does not arise in this case. Cut-off date is the cut-off date of the admission, not the cut-off date of changing the My lord, category. Counseling is the date when the candidates will produce themselves either through online or offline, my lord. But on that day, the authorities will determine. And thereafter, the final list will be published. Not prior to that. This is the procedure laid down in the statute and in the MCI also, my lord. And the Honorable Apex Court has given the preference therefore like that, my lord. The merit, after all, everything has to be determined on the basis of merit. And
It does not state that after completion of the process, you will be permitted.
no, that I'm not insisting. That I'm not insisting on that, my lord. I'm insisting as per rule, my lord. I am insisting only as per rule, my lord. The rule is
Rule is silent. There is nothing in the rule.
therefore, my lord, they cannot do what is not in the rule, my lord. Therefore, they cannot do what is not in the rule to deprive someone, my lord. They have to act fairly.
Act fairly, they have to.
They have done whatever they have done, but that is arbitrary exercise, my lord. That is not permissible under law. They have to strictly follow the statute. The rule does not allow them to do this in the midway. It has to be done on the day of counseling.
Now, if it is not provided in the rule, then how can they do it?
They cannot do it. They cannot do it. They have to determine on the basis of those candidates whoever will whoever will appear before the selection board or will submit the application through online, my lord. On the basis of their certificates on that particular day of counseling, they will determine. Not prior to that, the category will be determined. That is the rule.
Yes, correct.
Yes, my lord.
Is it the rule?
No, my lord. Because while applying, my lord, they have to apply category-wise, general category or SC, ST. So accordingly, the merit list is prepared, my lord.
Merit
list is prepared on the basis of the application, and while making the application, they have to specify under which category they are applying. Under general category or reserve category, my lord.
Yes.
So accordingly, they have now, my lord. Although the rule doesn't confer, doesn't provide for change of category, still the authorities have allowed them one chance, my lord, by this educational notice, to change their category, my lord. If somebody has made any mistake while making the application.
There is the requirement of rule, my lord. Yes.
They have provided one chance to the candidates, my lord. Otherwise, as per the procedure, while applying for a particular, for this course, my lord, they have to apply specifying the category at that point of time. And the entire selection and counseling will be made on the basis of that application only, my lord. On the basis of that application, my lord, the merit list will be prepared. General category or reserve category, PWD category, all categories, my lord. So they have to specify at the time of making the application, my lord.
If that is right, my lord, we have, my lord, my application is page number 34, my lord. And in that application, it is clearly specified.
That is a subsequent application.
No. This is the first. This is the
online application, my lord. That is accepted online, my lord.
They
but
cannot.
That will be considered at the time of counseling. The documents or other things, my lord.
My learned friend cannot stand in the two boards at the same time, my lord. Application means online application for admission and online application for counseling. It does not say, my lord, offline and any other application. And I have submitted my application, page 34. It is accepted as OBC NCL category. And my lord, I have given the copies, my lord, that shows that my name has been.
Where is your online copy?
Online, my page 34.
No. At the time of applying.
This is the online application for counseling.
Not for counseling.
Then what, my lord?
Appearing in the examination.
NEET examination.
Yes.
NEET examination UG and general category.
Where is that
Yes.
application form?
That is result is given, my lord. An application is not required to be, my lord, annexed. Result I have annexed as general category. 429 I have got, my lord.
You produce that application, we'll see under which category if I have applied.
I have applied under general category, my lord. At that point of time, I could not procure the NCL certificate. Obviously, certificate was those there, but I could not procure the NCL certificate. Therefore, I applied in the general category. And my lord, on the day,
You produce the form, we'll see.
No, he
by
is-
this time, my lord, my counseling,
He is admitting, my lord, he has applied under the general category.
Take the document.
Yes.
my lord, if the, my lord, days, my lord, counseling is over, my lord,
It is your fault.
not my fault, my lord. I have approached this honorable court in time, my lord.
What is the document? Hard to serve, that's for hard to serve. Hard to serve. Hard is hard with Monday. Origin application filed by at the time of applying for admission.
It is online, my lord. Not original is not type copy. Is only be there. It will be online generated only.
Whatever application is applicable to it.
Obliged, my lord.
Lordship, may I please your lordship? In lordship, in item number 17 and 18, my lord, the education department have filed affidavits, my lord. I have checked the record. It is not in the record. I may be allowed to tag it, my lord.
Item 16 too?
No, 17, 18.
Will call the matter.
On the last opinion, your lordship was pleased to call for the records, my lord. Your lordship recall.
My lord, I have received the record, my lord. Lord, I require some time, my lord. So,
The lordship recalls this matter, but the petitioner was dismissed without even an inquiry. I had argued on those points, my lord. And subsequently, initially they filed an affidavit in opposition, saying that the matter was infructuous. Subsequently, they filed another affidavit.
as per direction of this honorable court.
And
My lord,
in that affidavit, they took a complete U-turn and took a very different stand, saying that the inquiry against the petitioner was dispensed with. And therefore, your lordship was pleased to call for the records, my lord. So the records
my
have
lord,
been placed on this
another
matter.
date may be fixed, my lord. Today I have got some difficulty, my lord, and I have just received the record. So it will be disorganized, my lord, today. So
Can it be on 7?
My lord, and item 11 and 12, my lord. Oh, 17, my lord, it can be taken, my lord. 17. 17. Interim order passed earlier may continue, my lord.
But or do the better. Let's go. Yeah. Yes, for
Or my lord can have it on 18th, my lord. It will be a hearing day. It will be better, I guess.
18th and Mukuriba.
Achha.
Most
Obliged.
obliged.
No, only pass over for the time being, my lord. So K Gogoi will argue, my lord. He'll K Gogoi, my lord. His legs in another court.
May I please, your lordship? Well, this matter is relating to non-payment of salary. Service of the petitioner lordship in both the cases, provincialized with effect from 1/1/2021. My lord, immediately after provincialization of our service, one teacher of from my scholarship filed a writ petition
And in that writ petition, lordship, an interim order was passed directing the authority not to release the salary. Subsequently, that writ petition was disposed of in the year 2022, directing the petitioner in that case to file an appeal under section 14 of the Act, lordship. Accordingly, the appeal was appeal filed that was heard, but decision is yet to be taken. But the order passed in the writ petition is that the only direction was given to file an appeal, and in the provincialization benefit in respect of one petitioner, that is in the petitioner number was in second case, that will be subject to the outcome of the writ petition. There was no bar to release the salary, but they are not releasing the salary. Lordship, taking the plea of that interim order, your lordship will find in their affidavit file that is on 29/8/24. My lord, paragraph 5, 6, 5 and 6.
Where is the paragraph?
Paragraph relevant, lordship, paragraph 5 says that service of the petitioner was provincialized on 5 to 21, and paragraph 6, lordship, page 35, running page.
Paragraph
6, page 35, running page, lordship. Paragraph 6 of the affidavit.
Yes.
May I read, lordship? The answering respondent humbly begs to state that after provincial service of the petitioner, along with two other teachers, Amitabh Chaudhary and Abdur Rahman Mozumdar is the petitioner in the second case of so-and-so school, and thereafter their service had been posted at base school, namely so-and-so. In the meantime, on Suparna Sinha Chaudhary, a teacher of so-and-so, approached this honorable court in WBC number so-and-so for non-provincial offer service as per Provincial Act so-and-so. And the honorable court on 24 to 21, while issuing notice on the said petition, passed an interim order directing that the provincialization of the services of respondent number 6 and 7, namely so-and-so, shall not be given effect until further order. So they are the two petitioners in these two cases. As such, in compliance of the said order dated so-and-so, monthly salary of the petitioner Nirmal Chandra Das and Abdur Rahman has not been released. Thereafter, honorable court finally on 14/6/22 disposed of the said petition so-and-so filed by so-and-so with the direction to the petitioner to prefer an appeal before the Commissioner Secretary to the Government of Assam Education Department with regard her claim. And in the event of filing such appeal, the petitioner within the time specified as directed above, the Secretary to the Government of Assam Elementary Education Department shall dispose of the same within a period of 90 days with a reason order after considering all the relevant documents, record, appointment order, attendance so-and-so, and the respondent number 6 and 7 as the so-and-so district elementary education officer, deputy inspector, block elementary so-and-so, were directed to APL lordship. Accordingly, the government in the Department of Education so-and-so passed an order dated 3/8/23, your lordship will see, directing the office of the respondent answering deponent to instruct the district elementary education officer Hailakandi furnish relevant record. Accordingly, office of the deponent directed the district elementary education officer by order dated 7/9/23, who is the concerned DO has submitted on 4/10/23. After 23, your lordship will kind. Thereafter, the government by letter 6/5/2025 directed the office of the answering deponent to submit the original dice so-and-so record authenticated by the SSA along with the attendance register of the petitioner school and the other document. In terms of the said letter dated so-and-so, issued by the office of the answering deponent, issued letter so-and-so for submission of authenticated dice record of the school and the DO Hailakandi for submission of authenticated attendance register minus of the district, etc. so-and-so respectively. But the information has not been received from the DO Hailakandi and the mission director SSSM till now. After receiving the information from the concerned authority, the same shall be submitted to the government for taking necessary action. My lord, your lordship will kindly see the order of this honorable High Court lordship, page 25. What was the direction? Relevant, your lordship will find as page 29. Page 29. As the said Act 2017 Act itself provide an appellate forum, this writ petition is disposed of directing the petitioner, that means lordship Suparna Sinha, this is another officer, to prepare an appeal before the commissioner secretary to the government of Assam in the elementary education department with regard to her claim for disregarding her seniority, leaving her out of the benefit of provincialization under Act so and so. Such appeal shall be prepared by the petitioner if so advised before the commissioner secretary to the government of Assam in the education department on or before so and so, along with a certified copy of the writ petition including so and so, as well as affidavit of the director filing the proceeding, obtaining necessary acknowledgement. In the event of filing such appeal by the petitioner within the specified as directed above, the commissioner and secretary to the government of Assam in the elementary education department shall dispose of the same within a period of 90 days with a reasoned order after considering all relevant documents, record, appointment order, so and so, hearing of the petitioner, respondent number 6 and 7, and other district officer. Provincialization of service of the respondent number 7, your lordship will see, under the said act, shall be subject to the outcome of the said appeal to be preferred by the petitioner before the commissioner secretary to the government, the elementary education department. This was the direction of this honorable court. That is the respondent number 7, that means lordship, he is the petitioner in the second case. My lord, there is no bar that the salary cannot be released. That interim order was lordship has already been marched with the this final order. So that interim order is not forced at this stage, while the final order is passed. But they are not releasing the salary on the ground that the interim order passed in that petition, not to provide the service provincialization benefit.
Here, my lord, one sitting was held regarding hearing, my lord. Thereafter, my lord, the commissioner seeking some documents from the district, my lord. But we have not yet received that relevant document from the district, my lord, regarding appointment and this service records, my lord. And other thing is that, my lord, Suparna Roy, my lord, the petitioner in this case, but
In that case, not this case.
just now my learned friend has read out, my lord, that is page 25, my lord. She has filed an contempt for not complying this order, my lord. That has been page 25 was what my just now my learned friend has read out, my lord, that order, my lord. Suparna Singh Chaudhary, my lord. In that case, my lord, commissioner has directed to complete the appeal within 19 days. That is why she has filed an contempt. That is
90 days is yet to
oh,
over.
no, already over. She has filed an contempt that is listed on 15 on Monday, my lord. Well, so this matter may come along with that contempt, my lord. Regarding the my lord, issue, only thing is that if appeal goes against my lord, the petitioner, my lord, in that contempt petition, my lord, they will be adjusted probably, my lord. So let the my lord, hearing be completed, my lord.
The need to take this matter with contempt case.
By now 90 days, complete the hearing.
My lord. Well, here actually only thing is that
2020.
my lord, only thing is that we are seeking some verification from the SSA, my lord, regarding dice verification, my lord. We have not yet received, my lord.
SSA is not in America, it is Assam.
True, my lord.
Then
My lord, we have
how
not
many
received.
years you will require to obtain the inspection? Obtain that from
Some time may be granted, my lord. Will
So far dice is concerned, there is no necessity of dice because our service has already been provincialized.
that has to be verified by the department, my lord. My lord,
if you have any doubt about the order of provincialization passed by you,
My lord, actually, my lord, during provincialization, all the reports has been sent by the district, my lord. That is why there is some necessary to verify all the
So not
document.
those documents were furnished by whom? By your officer?
True, my lord,
District
sometimes,
Elementary
true, my lord, there are
You
some,
have no weight upon the district elementary petition.
sometimes there come out some discrepancies. That is why, my lord, verification is required, my lord.
Oh, that's all right. You carry out the verification, but how come? it- Can we allow it to indefinitely?
No, my lord.
Then
That is true, my lord. There is some delay, my lord. Some time may be granted, my lord,
time for what?
to complete the hearing, my lord. In the appeal, my lord. Filed by the, that, my lord, petitioner in WBC, my lord.
What's the number?
My lord, I don't know, because this was filed by another person. That's one of, what is the
Lord,
necessity, my lord? My lord,
contempt number
what is the
60
bar to release our salary? There is no bar.
Contempt case number
They
6.
can do lordship another 2 years serious, no problem of that, but they have to release the salary. What is the bar to release the salary? 2022 matter,
If the interim order then part with the final order, then how can on the basis of interim order it can stop their salary? Simple thing. Whenever final order is passed, interim order always part with the final order.
Well, 2 weeks time may be granted to complete the hearing, my lord.
that direction in that case we will not require lordship. Because we are paying for salary, that should be released. 90 days, that has over in 2022 itself, after almost 3 years. Our my lord, provincialization order is at page 23. Unnecessary lordship, they are hanging our salary. Only a fixed payment, lordship 10,000 something. I have not received a single point till date. If your lordship is fix this matter along with the contempt case, they will take another chance in the contempt case to take time. And in this way, lordship, this matter will linger. There is unnecessary lordship hanging this matter. Lordship, there is no bar at all. Only subject to provincialization, subject to outcome of that order. If the order is come against us, automatically I will out. On that day, I will not get salary.
The petition was not filed by the present petitioner.
Yes.
Then why should we take this matter with that on the petition?
Only because of
Which
that,
was filed by some other person?
only because of order dated, my lord, this 14/6/2022, my lord, they are not receiving salary, my lord. That page,
Where dated?
page 27, that is 14/6/2022, whereby, my lord, that petitioner was directed to file an appeal and directed the secretary to dispose of the appeal within 90 days, my lord. Only because of this order, my lord, they are not receiving salary. Filing another case, my lord, Suparna Singh Chaudhary's case.
So this petition has been disposed of.
My lord, true, my lord. But my lord, appeal not yet completed, my lord. Order, appeal of the order has not passed by the secretary, my lord. Some documents are required.
These
my lord.
decision will be the subject to the outcome of that result of that lordship. That can be.
There
My lord,
is also
appeal that has not been disposed of till date. Whatever decision your lordship will take in this petition, that may be subject to outcome of that appeal. If the appeal goes against us, we'll be out. And if the appeal is in our favor, lordship, then obviously our service will continue and we will get salary. But till that day, they are entitled till the date of decision of that may be taken up by them.
Well, let us complete the appeal, my lord, within 2 weeks, my lord.
Restrain you,
Appeal was filed by whom?
held by a Supana Senior, that is another teacher.
Not by you.
No,
Only because of her order, my lord, they are not receiving salary, my lord.
that order has not
How
put.
the petitioner is concerned with it?
True, my lord, they have challenged their appointment, my lord. After that, my lord, court has directed, this honorable court has directed to file an appeal to the Suporna Sodori. Only because of
Their
challenging their appointment.
In that case, we were the respondent. Our provincialization order was challenged. That matter was remanded to the authority.
In the
filing appeal.
hearing, they have also appeared, my lord.
As per order, we appear. Hearing was done in long back.
Only thing is that we have yet to receive some document from our district. After receiving the documents, we will file the final, pass the final voting. That is why I am praying
from whom you are not receiving the document?
from district authorities, my lord.
The authority.
My lord, district elementary education officer, my lord, Hailakandi.
PS 42, Lordship, that report has already submitted on 13/6/2025 by the district elementary education officer to the director. PS 42, their affidavit.
Yes, if this information you have received.
Some other information also required, my lord. That is why, and also, my lord,
What other information?
my lord, regarding provincialization of the petitioner and the respondents, my lord. And SSA also, we have some information also on the SSA. my lord. 2 weeks time may be granted, my lord. My lord, in the meantime, we will try to complete, pass the order in the appeal.
In this way, Lordship, they will take another, Lordship, 1 year, 2 years time. Because they will not dispose of this appeal. Inordinate delay. 90 days, now more than 3 years.
Okay, you complete the process, but in the meantime, release her salary. She has been discharging her duty in provincialization and also prior to her purpose.
I will take up the matter with the authority, my lord. I'll take instruction.
What sake of they have filed affidavit saying so, Lordship, because of that. This is the only ground. What instruction he will receive? Because of the interim order. This is the only ground.
Now we are disposing of this release your salary in a period of weeks from today.
Your Lordship, as a last chance, Lordship, if your Lordship
Now,
wanted.
today we are disposing of the
Yes, Lordship.
granting them 2 weeks time to release your salary.
Lordship.
Your pair is to release your salary.
No, yes, Lordship. In both the petition, yes, Lordship. Obliged.
Well, this matter maybe can be fixed on 16, Malad, as agreed by the parties, Malad. 16.
Tuesday, Malad.
Tuesday, Malad. Next Tuesday, Malad.
Coming Tuesday.
Tuesday.
Malad, some time is required.
That's agreed by Lord Advocate of both the parties.
March.
16/9.
March.
May please also.
Yes.
But in this case, the petitioner has challenged the Malad, the nomination of respondent number 6 as the president of Nalar for High School, Malad. What you will find page 23, Malad.
Is the part?
Page 23, Malad.
23.
Malad.
Yeah.
By these communications, my lord, issued by the Inspector of Schools, Nogau, my lord, the Lordship will find by which, with may I read, my lord. With reference to the subject cited above, I would like to inform you that the government of Assam has released two reconstructions of school management and development committee, which have already completed period of time. Therefore, you are requested to forward two names of person for each president and vice president as per following criteria on or before 2/10/2021, my lord. Subsequently, my lord, this letter was issued to the headmasters of the, my lord, Nalar, to all these schools, my lord, within the jurisdiction of, my lord, Nagaon district, my lord. Subsequently, my lord, the headmaster of schools, my lord, forwarded the names. Lordship will find page 32. By which, my lord, the headmaster of the Nalarpar High School, my lord, forwarded the names of the, my lord, serial number 1 is my name, my lord. Post, my lord, in the right hand side, lordship will find president, and along with, my lord, two persons, my lord, and also two names for the post of, my lord, vice president, my lord. Serial number 1 is my name, my lord. Now, lordship will find the impugned communications at page 35.
How many names have been forwarded by the headmaster?
By 3, my lord. 3 for the post of president, my lord. The serial number is my name, my lord. Next one, Moktab Hussain, and 3, Pranjit Bora for the post of president. For the post of president, my lord. Now, lordship will find impugned communication, page 35.
কিন্তু ডিসি রোল আছে রে
This was issued by the inspector of schools, my lord, dated, my lord, 8/9/2022, my lord. To the headmasters of the, my lord, concerned school, my lord. With reference to the subject cited above, I have the honor to inform you the following persons have been nominated as president and vice president of new SMDC of your school. Below, my lord, lordship will find president in the, my lord, below part, my lord, one Abhijit Bora, my lord. Whereas, my lord, his name has not been forwarded. That page 32. Page 32, 3 names have been forwarded for the post of president, my lord. And these, my lord, Abhijit Bora.
None of the person mentioned in this letter has been appointed.
Yes, nominated as president,
Abhijit Bora.
my lord. But his name has not been forwarded, page 32. Page 32, just, my lord, I have pointed out.
The question is whether the inspector of school.
Yes, now, my lord, I am coming, my lord.
As a person whose name is not forwarded.
Exactly, my lord. Exactly. Now, lordship will find the government of Assam Education Department had issued a notification, page 39, dated 24 June 2016.
Yes.
Now, lordship will find page 42. Lordship got it, my lord. Selection process of president and vice president of SMDC. The inspector of schools, after consultations with the principals, headmaster, and local people, will forward 2 names to the director of secondary education Assam, each president and vice president, with recommendations of deputy commissioner within a period of 30 days. After considering the names, director of secondary education Assam will provide the list to the government with his comment for selecting single names after comparing data of both the candidates, and then government will approve the committee. My lord, the name of the respondent number 6, who has been nominated as president of the SMDC, has not been, my lord, forwarded by the headmasters, my lord. Now, lordship will find the affidavit filed by the, my lord, respondent number 3, page 43, my lord. Page 43, my lord. The inspector of schools, my lord, have filed an affidavit. Here, lordship will find they have annexed one notification, page 48. Lordship got it, my lord.
Yes.
Page 48.
48. 48.
My lord. Affidavit filed by the inspector of schools.
Annexure
on number
1.
3.
Page number 50.
48. Page 48.
Maybe, my lord, That notification dated 27 October 2021, my lord. 27 October 2021, my lord.
আপনার 51 মোৰ 50 খতম হৈছে
Lordship got page 48. Running page, my lord.
48 is order of the High Court, petition number 5005. And page number 50 is the affidavit filed by the inspector of
Nogao.
Nagaon.
Then Lordship will find annexer 1 in that affidavit.
One of that.
There's two. Lordship got it, my lord. This notification is 27 October 2021, my lord. In partial modifications of the guidelines for construction of school management and development committee issued by government notification number so and so dated 24/6/16. That, my lord, in my repetition, that notification has been annexed, my lord. 24/6/16. And letter number so and so dated 5/4/2017. The deputy commissioner is hereby empowered to select president and vice president of school management and development committee of an educational institutions of the concerned district with approval of the guardian minister. Now, Lordship will find their statement in the affidavit at page 46. In that affidavit, my lord. Page, my lord, it may be, my lord. At paragraph, my lord, 5. Search paragraph 5, next paragraph, my lord. Next page, my lord. Internal page 4. Line starts as regards to the Nalarpar High Schools, my lord. Second paragraph, Lordship got it, my lord. As regards to the Nalarpar High Schools, the name of Abhijit Bora, BA as President, and Deepali Mes, BA as Vice President of the School Management and Development Committee were proposed by the local public representative. The recommendations were duly approved by the District Commissioner and Honorable Guardian Ministers of Nagaon District. That proposal, as per their statement, has been made by the local public representative, my lord. Whereas, even if, my lord, I am assumed that the notification is ineffective, my lord, then it is the approval of the guardian ministers and the notification that Lordship 27th October, my lord, in their affidavit, that the deputy commission is empowered to select president. So, my lord, how, my lord, the local, my lord, public representatives, my lord, can propose the name of the president. And again, my lord, Lordship will find that notification is of 27 October 2021, my lord. Lordship, that the notification annexed with the affidavit of the respondent number 3, my lord. Whereas the, my lord, my and the school new constitution of the new SMDC was started prior to that, my lord. So my submission that Lordship will find in the name has been, my lord, that the improved communication is 8/9/2022. 8/9/2022, page 35.
Yes.
That date is, my lord, 8/9/2022. And in the annexer 1 at page 35, my lord, by which the inspector of schools asks the headmaster of schools to forward the name of president and vice president on or before 2/10/2021. And that notifications annexed with the, my lord, affidavit of respondent number 3 is dated, my lord, 27 October 2021. So the process for, my lord, constitutions of the new SMDC has already started before, my lord, issuing these notifications, my lord. The name has already been forwarded, and the letter by which the inspector of schools asked, my lord, to forward the name of president, that has already been initiated prior to, my lord, issuing this notification dated 27 October 2021. These notifications, my lord, cannot be made retrospective, my lord, in operation. I have filed, my lord, reply, my lord. That in my reply, my lord, I have specifically stated that paragraph 4 and 5, my lord. This first, my lord, the name of the respondent number 6, my lord, has not been forwarded. In spite of that, my lord, his name has been nominated. He has been nominated as president, my lord. And in the impugn communication, page 35, Lordship will find there is no any whisper that whether the deputy commissioner has selected that page 35, my lord. If Lordship once again, my lord, peruse that part, my lord. There is no any whisper that the deputy commissioner has, my lord, selected the respondent number 6 as president.
Definition to nimile.
Itself, my lord, is illegal, my lord. Arbitrary, my lord, that may be, my lord, set aside, my lord. That's why, my lord, is honorable court was pleased to pass an interim order in this case.
That interim order is occurred.
Yes, my lord.
Yes, madam.
Cannot be made retrospective because the process has already been initiated and there is no any whisper in the impugn communication, page 35, my lord, whether the deputy commissioner has selected the respondent number 6 as president of the school management and development committee.
This is the mean of that. Your lordship, DC is the concerned district, your lordship, authority, your lordship, who are empowered to select the president and vice president, which notification is already there, your lordship, white dated notification memo number so and so dated.
No, you say the stand of the petitioner is that notification was issued on 27 October 2021. And months prior to that, the process was started. And this notification cannot be given a retrospective effect according to the petition. What is your submission on this point?
Till date, your lordship, the cases that are in connection with this kind of similar facts, matters and similar facts, your lordship, circumstances, only DC has the power to choose the candidate, your lordship.
No.
They recommend the name, your
When
lordship.
the process was started, this notification was not there. Would you follow my point?
Your lordship, in our paragraph 5,
And you see in Annexure 5, the inspector has
Page 35.
nominated a visit for a as president and Dipali Mayor as vice president, where it is mentioned that his name was recommended on the basis of the recommendation made by the deputy commissioner. Is it there?
after selection of your lordship, DC, your lordship recommendation letter, it was the letter was sent like this only, your lordship. This is the formation, your lordship, of SMDC. And your lordship, in our affidavit opposition, page 45, paragraph 5, your lordship, inspector of school already stated that. I would like to.
For respondent number 6.
No, my lord.
No.
Hmm.
Notice to sir.
Yes, my lord.
Is there any order to that effect?
Yes, yes. Yes.
When?
My lord, already reported, my lord. And my lord, yes, that's the service, my lord, I have affected to that.
Your lordship, paragraph 5, I would like to read it, your lordship. Stated paragraph 4, your lordship, it shows that DC has power, your lordship, and thereafter, your lordship, paragraph 5 states elaborately, your lordship, our stand.
No, you see, prior to this notification dated 27th of October 2021, DC has no power.
And collected names of the persons and
issuance of this notification.
And your lordship, collected names of persons for president and vice president from the local people, your lordship. And thereafter, concerned headmaster, principal of high and higher and senior secondary school, and also.
Right, but is it provided in the rule?
Hey, this is the rule. Way too much curious. This is the way, your lordship. This is the.
Where it is provided? Which rule?
Your Lordship, in white letter number, Your Lordship, that is already annexed in Annexure 5, Your Lordship. Inform the concerned headmaster, principal to form the school management. SMDC, Your Lordship, is the SMDC is the real, Your Lordship, to formation of that later, Your Lordship, after approval of the person's name, Your Lordship. And it was elaborately stated in our affidavit. Kindly, I may allow to read it, Your Lordship.
Which one?
That formation, Your Lordship, how that selection is made, Your Lordship. That is page 45. 45, paragraph 5 onwards. It was clearly, elaborately stated.
No, is it provided in the rule? Come to page number 42. Election process of president and vice president of assembly.
Hmm.
How it is provided?
That rules, Your Lordship, that criteria, Your Lordship, already regulations, rules, and earlier time period also, Your Lordship, it is going this way, Your Lordship, following the aforesaid government notification. So, Your Lordship, I may allow to read it, Your Lordship, this paragraph 5,
Paragraph 5 of
page 45,
your affidavit?
my affidavit.
Yeah.
I would like to read it, Your Lordship.
Yes.
That the deponent begs to state that the then inspector of school, by following the aforesaid government notification, collected the names for president and vice president from the local and concerned headmasters, principals of the higher, senior secondary schools, and also consulted with the public representatives, including local renowned person thereafter, prepared the list of nominations containing the name of president and vice president, and subsequently submitted in respect of all government provincialized higher and senior secondary schools to the district commissioner Nagaon for approval. Here district commissioner is the main authority person, Your Lordship. After receiving the recommendation approval from the district commissioner as well as from the guardian minister, the answer, that is continuation in page 46. Guardian, white letter number so and so dated 8/9/2022, that is annexed to writ petition, which is already annexed in annexure 5, page 35. Inform the concerned headmaster, principals to form the school management and development committee of the school with approved persons. As regards to the Nalapara High School, the name of Abhijit Bora, BA, as president, and Dipali Mej, BA, as vice president of the school management and development committee were proposed by the local public representative. The recommendations were duly approved by the district commissioner and the honorable guardian minister of Nagaon district. The headmaster of Nalarpar High School had also been duly communicated to form the School Management and Development Committee, SMDC, of the school. Why it's later dated so and so, 8/9/2022. And after that, Your Lordship, that letter has published, Your Lordship. Accordingly, the headmaster of Nalarpar High School formed the School Management and Development Committee with Abhijit Bora as president and Dipali Mej as vice president. It is to be
We have made the question. You see, annexure 1, page number 23 of the petition.
his name was petitioner name was not approved by the SMDC, Your Lordship.
See, the process was started on 28/9/2021. And the notification by the Principal Secretary Government of Assam, Secretary Education Department, was issued on 27 October 2021. So the process was started month prior to issuance of this notification. Can this notification be applied retrospectively? That is the
Karibo. নোৱাৰাটো কোনো কথা নাই। His name should be approval by SMDC.
Again, you are missing the point. First of
My lord, okay. In my reply, my lord, paragraph 4 and 5, my lord, specific.
Your lordship, my point is, your lordship, it was elaborately given 4 and 5, your lordship, affidavit in opposition.
Obliged, my lord.
Deeply obliged. And his name was not recommended by SMDC.
The 17 and 18, the same case, my lord. In this regard, my lord, they have already filed an additional affidavit. By that affidavit, my lord, they have already disclosed this first is yet to be filled up, my lord. My lord, that affidavit is not available with the record, my lord. Kindly record if that affidavit may be called for and take up at 2, my lord.
poster like vacant.
16 poster lying vacant. Some poster lying vacant. my lord.
All the
At 2, 17 and 18. Both the same method, my lord.
Please, Your Honor. My lord, they have to file the instruction, my lord. My lord,
Your lordship.
my
In this matter, your lordship, early morning, your lordship, I mentioned that your lordship affidavit is already sent for vetting, your lordship.
My lord,
Lordship, kindly-
not required, my lord. Only instruction, my lord. They have to submit the seniority list, my lord. My lord, can you see the order? Last. Order dated 11/8, my lord.
order dated,
Last paragraph, 11,
order dated,
11/8, 2025. Last portion, my lord. My matter, my lord, I am the I'm the in charge headmaster of Kasuri High School, my lord. My lord, after my lord, demise of the headmaster, my lord. In my petition, kindly see page,
so Mr. Akira,
my lord.
their instruction, can we dispose of this matter?
Yes, my lord, kindly, the covered case, my lord. Similar matter has been disposed of by. Similar matter. My lord, kindly see paragraph 18, my lord. An ad hoc employee cannot be replaced by another ad hoc, my lord. Ad hoc employee. Paragraph 18, my lord.
Here.
Similar matter, my lord.
But their instruction and their affidavit,
My lord, kindly see
proper
the
dispose of this matter.
pursuant to the this honorable court, my lord, and a speaking order has been passed by the director, my lord. Can we see page, my lord, 27, my lord, in my petition, my lord. Speaking order, my lord.
Disposed whole sentence. Please. Right. I'm
The last paragraph, my lord. And then taking time, my lord, last occasion, they are taking time.
Letter affidavit of
My lord, may I please your lord. My lord, I am appearing for the private respondent. At present, I am holding the charge pursuant to the impugn order, my lord. The interim order was declined by this honorable court. My lord, the issue is that, my lord, the client which my respected senior friend is representing, my lord, he do not have the requisite qualification of BEd to holding the post for the purpose of headmaster of a school, my lord. That is the basic crux of the case, my lord. Now, my lord, what they are harping on the ad hoc, one cannot be replaced by another ad hoc, my lord. That will come when he has the qualification, that plea can be taken up. Now, here is a case, my lord, wherein, my lord, the initially when the headmaster was, my lord, demise, then, my lord, I was also, my lord, have the qualification, but for my family affairs, as the a near one had died. No, I'm submitting, my lord. I will not disturb my senior friend, my lord, with all respect, my lord. Due to the demise of my very near one, my lord, I have extended that at this moment, I am not intending to hold the post of the in charge headmaster, my lord, immediately. Then, my lord, the director, my lord, has given him the charge because as there was no other person except me having the BEd degree. Now, later on, my lord, when I said that at this moment, as I am entitled and eligible, now I should be given the charge basing on my qualification, and even his insership had also been put into challenge. When the matter was in session before my lordship's, my lord, the department revoked his insership order and conferred it to me, my lord, being the only eligible and qualified person in the said school, my lord. Now, he is challenging that order of, my lord, conferment of charge to me, saying that one ad hoc cannot be replaced by another ad hoc. And as I have given the earlier undertaking that I am not eligible to take the charge, so therefore,
yeah.
my lord,
If this court is sitting of the matter,
my lord.
how the court take the
No, my lord, the issue is that regarding, my lord, that's why, my lord, the issue of, my lord, the cancellation of his charge, my lord, is there, and the affidavit is required, my lord.
And your
Affidavit is
lordship,
required, that how this happens, it will come in the affidavit, my lord. And even, my lord, I have also prepared an affidavit, but for my personal difficulties, my lord, today I could not file the same. I will bring everything on record, my lord. Just a 2 days time may be given, my lord. By Monday,
already
I'll file it,
sent
my lord.
vetting also. And your
And-
lordship, in our affidavit also, we have stated that he has not, your lordship, obtained the eligibility criteria for the post of headmaster superintendent in high school, madrasa, as he has not hold BA, BSc or BCom with BT, PhD degree from any recognized university.
That's all right, but tell me when your affidavit would be ready.
It was already sent for vetting. Only
Not concerned
No, date.
date, any date may be given, your lordship. Any date may be given
Sorry,
next week. Any
Next
date may
week,
be
date
given.
may be fixed, my lord.
Yes, your
Date may be fixed, my lord.
Sir, is there a clear or no? Or also for the-
Four, my lord, respondent four.
Not for the court. That's what
I am appearing for one,
Secondary
2,
question.
and 3.
What question? What? Third in part is the matter on like this. In the next time, that and oh yeah,
My lord.
file there.
My lord.
My lord, make it 18, my lord.
18.
18.
Okay, right.
It's
You
pretty much
take
it.
back this judgment, keep it,
18,
produce it on that day.
My lord, my
My
lord. My lord, if matter may not be, my lord, disposed of on the next date, my lord, can we,
We'll try, we'll try. No such observation is necessary at this.
My lord.
because my lord, they are threatening me on every side, my lord. They threaten me to suspend, my lord. Can you see they are
Both written.
inspector threatening, my lord, block officer threatening me
File
to
an FIR.
suspend.
My lord. Law will take its own course, my lord. Oblige, my lord.
Last page to sign.
May I please, your lordship, my lord? This case was listed, my lord, day before yesterday, my lord. And on the same day, my lord, day before yesterday, I have received one, my lord, affidavit in opposition filed by the, my lord, concerned director. My lord. This affidavit doesn't reflect anything save and except that while conducting the inquiry, my lord, no prior notice was sent to upon me, my lord. And on the day of, my lord, alleged, my lord, inquiry, my lord, I remained absent, and in fact, I had to remain absent, as I have admitted before your lordship, my lord, on many occasions that one of my relative, my lord, he succumbed, my lord, he died, my lord. And because of that, I could not be present in the school, my lord. And they have admitted in their affidavit in opposition, my lord, running page 107, my lord, para number 3, my lord, filed by the director, my lord, which was filed day before yesterday, my lord, that no prior notice was given.
Elementary.
And the, my lord, issue is altogether different, my lord. If your lordship kindly turn to the, my lord, impugn order, my lord, that is at, my lord, page 97 of my petition, my lord, annexure 24, my lord. I fulfill, my lord, each and every criteria, my lord. Earlier, there was a, my lord, dispute between two schools, my lord. And finally, after, my lord, 2-3 rounds of, my lord, petition, my lord, my school was, my lord, declared to be the genuine school, my lord. Your lordship is well aware of that, my lord. Lordship will kindly come to page 97, annexure 24, my lord. And the operative portion at page 99, my lord.
This matter, Mr. A. Fukan has been assigned, so lordship may take up after some time. After some time. Okay, no, I don't.
May I please, Lord. The last date, Lordship, I was directed to furnish some judgment, Lordship. Provincial Lordship. And on that day, Lordship, I prayed for allowing me to submit one detailed list of dates, Lordship. I have prepared that, Lordship.
The 11th paragraph.
Lordship. Which one, Lordship? Kobiram Rajbangshi, Lordship. Page number 3, Lordship. Page number 3. Page number 3, Lordship. Lordship, the only question in this case is that whether the petitioner shall be entitled to the benefit,
Paragraph
which
number.
Lordship, page the paragraph number here is written 4. Not page number 3, Lordship. Third paragraph, Lordship. Third paragraph. The only question in this case is that whether the petitioner shall be entitled the benefit which was granted subsequently to the retirement of the petitioner, considering the hard facts and
considering the fact that the petitioner had rendered service for more than 32 years continuously, I deem it provided the benefit of 1989 schemes, that is, annexure DNA should be given to the petitioner. No doubt, it is not. Lordship, then Lordship, clause 2, Lordship, pension for Assam service employees are governed by Assam Service Pension Rules 1969. Rule 31 provides for conditions of qualifying service. It is quoted below. Rule 31, conditions of qualifying service. The service of an officer does not qualify for pension unless it conforms to the following conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Thirdly, the servant must be paid by the government. Provided, lots of important, provided that the governor may, even though either or both the condition 1 and 2 above are not fulfilled, declare that any specified kind of services rendered in a non-gazetted capacity shall qualify for pension. And number 2, an individual case and subject to such condition as he may think fit to impose in his case, allow service rendered by an officer to count for pension. Lordship, the rule 31 is, so far my understanding, Lordship, the rule 31 is for counting the services for computation of pension, Lordship. It allows the government to count, and for that following rule 31, Lordship, government has time to time published, Lordship, notifications, Lordship, office memorandum, Lordship, particularly, Lordship, a notification, so far I remember, Lordship, published on 20 May 2009, Lordship, for granting pension and discharge to master roll labour, Lordship, by the Pension and Public Grievances Department, applying, Lordship, Rule 31, Lordship. It empowers the authority, Lordship, government, Lordship, to count the officiating period, Lordship. And it is not barred. Yes.
Well, these government of Provincial regarding master role employee at that 11 point of time 1997. Okay? Here the issue is something different. Here the issue is new pension scheme and old pension scheme. That is master role employee, that whether this length of service will get the benefit or not. And Lordship, now my friend has shown that impugn order, there is one condition that they should file an undertaking and the new assumption they have to contribute. In the meantime, my instruction is all these persons are contributing to that new pension scheme. And as per new pension scheme, they are contributing after this order of 2013. As well as my friend has shown one order that is page number, he has annexed it in page after the page number 51, where two persons have been shown that Mukundo Deka and Homeswar Kolita, my lord, they are getting pension, my lord. In view of the person to the order of the court, my lord, Lordship will kindly see that particular letter. It's a letter written by the Joint Secretary to the Government of Assam, Elementary Education Board, to the SCRT. My lord, may I read the contents of the letter, my lord? In inviting reference to your letter on the subject cited above, I am directed to convey no objection of the Government Elementary Education Department towards the proposal regarding regularization of the ad hoc services. It's make it clear the ad hoc services. Ad hoc services period and counting of past services for the purpose of computing pensionary benefit only and allowing pension to other benefits under the Assam Rule 1996 to so and so, to so and so. Now this letter is allowing the director essentially giving an no objection, and this no objection has come from the
Commissioner and Joint Commissioner, the Government of Assam, my lord, respond number 6. Then only if they have received these two persons, they can they will receive the pension scheme. And the same time, my lord, these two persons' name was there in the order which he is challenging, my lord. If their names reflected in their original, their name also reflected in serial number 13 and 21 of the order my friend is challenging, my lord. Lordship will get it in page number 32 and 33, my lord.
Yes.
And now, my lord, last occasion, my lord, I have submitted one order where in a order passed by the present Commission Secretary to the Education Department, my lord, rejecting the pair of getting old pension scheme. That is order dated 25/7/2025, my lord. The two paper, my lord, where contempt has been filed against the for not complying with the order of the court, my lord, based on which that order has been passed, my lord. So ultimately, all these petitioners preparing requesting for under the old pension scheme has been rejected, my lord. And this is the order my friend is relying on for the two persons. This order has been passed allowing saying that no objection to the SCRT if the pension is granted, madam. These two persons allowing it is here he cannot pray that he should be treated similarly, because this is a negative benefit they have got it, madam. Their names figure in that list where my friend is challenging, madam. So a person getting a negative benefit, he cannot rely on it.
So according to you, they have wrongly given the benefit.
My lord.
According to you, this person in the letter, like in the page number 51.
This no objection is granted by the state, my lord. No objection is granted by the state if the pension is given, my lord. And in the impugn order itself, their name figure, and they are said that they will be entitled for under a new pension scheme, and they will grant the no objection.
Are you admitting that you have given the benefit
My lord,
wrongly to them?
no, till today, my lord, that instruction I don't have it, but this is the no objection given to the state with the SART if it's allowed, my lord. Even assuming, my lord, this has been granted, my lord. This is a negative benefit they have got it. And lordship, that
In support of that argument, you have to first admit that you have wrongly given the benefit to them.
my lord,
Otherwise, you cannot
this
submit it.
since this page 51 is issued by the state, my lord, they have to justify, my lord, how this benefit had been given, when in the recent order all the benefit, my lord, has not been given, because they are said that they will be entitled to a new pension scheme, my lord. Lordship, that 2-page order, latest order, my lord, I have submitted yesterday, day after last occasion, my lord, on 25/7/2025, my lord. All the payers have been rejected, my lord, of all the employees. Second page, my lord, decisions, what you will see.
Or suffered or or
Two.
Response number 1, lord.
any argument? Yeah.
I have no other argument, lord. Lord, the service of the petitioner has been regularized after 1st February 2005. Because prior to that,
He was ad hoc.
they were ad hoc appointment. And lordship, that section 31, lordship. Section 31.
Rule
says-
31. Rule 31.
I'm sorry, rule 31. That has to be, secondly, The employment must be substantive and permanent. So therefore, because their services were regularized post 1st February 2025, they are entitled for the new pension.
Obliged.
This case was large. High level. Copy to associate court of the first. And I prepared a list of dates with the events, my lord. Your lordship can have a look at it. Itu আমার against করতে to be the second full copy. Maybe would like to hear same only. One same no. বইবা না মই কৰো
Yes.
Fine. Well, in fact, before starting matter, I'd like to point out that there are two matters before your lordship. One is wherein I am the accused, and one is where I am the informant of the case regarding the same issue.
What of
Regarding
petition for the accused?
sorry, my lord, I could not get you, madam.
What in one of the petition you are accused?
Yes, madam. And one of the petition, I am the informant regarding the same issue. Regarding that's the mark sheet which is concerned here, madam. In my case, final report was given. And in the other case, I have been made an accused. That is under challenge for quashing. That is criminal petition number 74 is the quashing wherein I am the accused of the case, madam. So we are taking up probably criminal petition number 74.
Yes.
In this case, my lord, what happened first initially that on 2/2/2016, a report was published in Sentinel newspaper wherein it was stated that the accused petitioner got 21 plus 9 marks in English in BCom as per mark sheet. On the basis of that, my lord, an FIR was filed by 4 persons. On 2/4/2016, FIR was filed by 4 persons.
Page number?
My lord, that is as page 18, my lord. I'll read, my lord. To the officer in charge of Jorhat Police Station dated 2nd day of April 2016. Subject Azahar, with due respect, I am to inform you that Rana Goswami, candidate for Indian National Congress, in the forthcoming assembly election, in a press conference held on 17th day of March 2016 at Jorhat Press Club, claimed that he has passed BCom exam from Dibrugarh University in the year 1981. And his roll number in BCom examination was 858. Copy of the publication made in the newspaper Doinik Janambhumi dated is annexed herewith. Subsequently, in the affidavit filed with the nomination papers, Rana Goswami claimed that he has completed Bachelor of Commerce from JB College Jorhat under Dibrugarh University and passed in the year 1981. But subsequently, petitioner query came to know that his Rana Goswami has not passed the BCom examination in the year 81. The petitioner got a copy of mark sheet against the registration number 9334, roll number 858, College JB College examination BCom, as furnished from the office of the Dibrugarh University, wherein it is categorically stated that the candidate Rana Goswami got 25 marks in English paper and his mark sheet shows that he has failed in the BCom examination against the aforesaid roll number. That from the newspaper publication, the petitioner came to know that the said Rana Goswami has shown as mark sheet in a press conference given by him on 1/4/2016. However, Office of the Registrar of Dibrugarh University with reference number such dated such issued a letter, Pratap Jyoti Datta, Digambar Road, Jorhat, a reference to the reply to RTI application. Copy of the letter is annexed herewith. In the reply, Public Information cum Law Officer Devraj Sharma of Dibrugarh University furnished the mark sheet of Rana Goswami registration number such, roll number such, JB College Jorhat. That from the perusal of the mark sheet as furnished by the Dibrugarh University authority, it is crystal clear that he got 25 marks in English subject and the result was declared as fail. Hence, it is submitted that to make an inquiry with the Dibrugarh University authority. Further contact number of registrar DU is such and said number is furnished to Pratap Jyoti Datta by the University authority through the above referred letter. That from the information as furnished by the Dibrugarh University, it is crystal clear that Rana Goswami not only made a false statement in affidavit, but also manufactured false mark sheet for unlawful gain. However, by making the false statement through affidavit and public media, he has cheated the voters of Jorhat Assembly constituency. That from the newspaper reporting in the Sentinel dated 2/4/2016, it has come to know to the petitioner that the said Rana Goswami has presented a mark sheet before the press, wherein claimed that he has secured 28 marks in English and got 9 marks in internal assessment, which is clearly in contradiction with the statement of authority of Dibrugarh University. And from the statement of Rana Goswami, it is crystal clear that there is a manipulation and forgery on his part in the LS mark sheet shown by him, and he is liable to be punished in accordance with the law. Copy of the newspaper publication in the Sentinel dated Iman is annexed herewith. That from the above facts and circumstances, it is crystal clear that the Rana Goswami has committed the offence of cheating and forgery, along with the other offences punishable under the provisions of law. The petitioner is therefore requested to register a case and to act in accordance with the law. Now the contention is that, my lord, this full person has filed the year. But I, in the meantime, has obtained one certificate from the JB College, my lord, my parent college, my lord, wherein it is replied to me, my lord, that I have participated in one JB College.
Page 24.
If your lordship will see annexure 9, page 53. The college in which I studied, which is under the Dibrugarh University, my lord, has given me a certificate, and that is also a subject matter of a civil suit, my lord. To Sri Diganto Borua, Advocate, Guwahati High Court, Guwahati, dear sir, in response to your legal notice, because you have to write a legal notice, dated 7/4/2016, I am furnishing the following facts points for clarification. The result of BCom examination held in 80 was declared in 81, and as per result sheet, the Rana Goswami BR in roll number 851 was declared passed. So the same roll number which they are alleging in the FIR and the same document, the college on from which I obtained the certificate, my lord, stating that I have passed the BCom examination, and they have issued me a certificate to that effect. The university provided, second point, my lord, the university provided furnished the mark sheet to the college in respect of each student candidate appeared in that examination, and the college authority delivered the same to the candidate. Further, the college authority issued provisional birth certificate to the candidates on perusal of mark sheet and result sheet provided by the university. Other records of that period are now not available in the college except the result sheet issued by the university. No two different mark sheets were issued to Goswami by this college, so far my knowledge is concerned. So the Jagannath Burwa College has given a certificate, my lord, stating that. So in that view of the case, there will be no case against me, my lord. I have annexed all the other documents. If your lordship will go one by one. Serial number 4. Well, pending all these events, my lord, I have also filed a title suit, my lord, which was numbered as 49 of 2017 and is available at page 35. Now, what was the prayer and all? I'll read your lordship.
Not necessary, we have to examine it.
No, my lord, one fact is there, my lord. Law, as I have understood, my lord, by reading, my lord. If on the same issue, a civil suit is pending, my lord, then the declaration of civil suit will be binding on the criminal courts, my lord. So, what was the prayer in my title suit? If your lordship will look into at page, last prayer, my lord, portion, at page 44, my lord. The plaintiff, that is Rana Goswami, therefore claims a judgment and a decree of declaration that the result of the plaintiff as per result sheet dated 11/9/18 issued by the Dibrugarh University under the signature of the defendant number 3 to different colleges under Dibrugarh University, including the pro forma defendant number 4, that is Jagannath Borua College, Jorhat, and the plaintiff's mark sheet under the signature of the said defendant number 3 sent to the said college, and that the result of the plaintiff as disclosed in the said result sheet and also in the mark sheet are correct, and that the plaintiff has passed his BCom examination held in 81, and that the BCom degree is behold as a valid one. Then the second decree at page 45, a decree for declaration that the information submitted by the office of the defendant number 2 by letter dated such in response to RTI application by the applicant Pranabjyoti Datta of Digambar Road, Jorhat, based on tabulation sheet was wrong. So the facts remain, my lord. On the basis of this RTI, the whole case was filed. Then permanent injunction and all this, temporary injunction and all this. So these are the two main prayers, my lord, that my result that was declared is a valid one. And the second one, that the RTI application that was short for is not correct. It should be declared as not correct, my lord. And I have annexed all those tabulation sheets and other which have been seen. If your lordship will kindly look into, my lord, from page 21 onwards, my lord. The police during investigation, my lord, has seized certain documents from me, my lord. That is exhibit 20, annexure 2. I, Tulumoni Dwara of Jorhat Police Station, do hereby seize the below noted certified documents on being produced by Rana Goswami, son of such of Jorhat, in connection with the above case reference. The seizure has been made in presence of witnesses below, resident of Rana Goswami, description of seized article. Certified copy of BCom final examination mark sheet in the year 1901 under Dibrugarh University. Certified copy of Dibrugarh University admit card by number 858. Certified copy of the birth certificate issued by JB College Jorhat dated 29/9/81. So these documents which are seized, my lord, I have annexed it, and there is another annexure that is the original one. And if your lordship will see, these are the document, my lord. Dibrugarh University admit, name is that Rana Goswami, roll number 858. That is the contention in the FIR. Registration number such of Dibrugarh University to the BCom 2 years degree course examination of 1980. Two comments on 6th April 1981. So this is my admit card that I have appeared, and accordingly the certificate of Jagannath Borua College, Jorhat. This is to certify that Sri Rana Goswami passed the Bachelor of Commerce 2 years of this college under such pass certificate. English language is there, my lord. During his career in this college, he was found regular in attendance and diligent in study. All these are there, my lord. So the college has issued the pass certificate. Then the mark sheet I have annexed it is nothing. So these are not denied by the college who have issued me, my lord. Then the other document, my lord, the tabulation sheet, my lord, page 26. Here you go. That means annex. So this document F was seized from the informants, madam. So, my lord, the charge sheet for which I am coming up for quashing, my lord, is starting from page 27, and the relevant part is at page 29, the contention, my lord. Page 29. The brief description of the case is that on 2/4/2016, the informant Isha Prasan Bordole, son of such, all these named 3% other lodged a written FIR before the Jorhat Sadar Police Station and informed that on 17/3 on a conference at Jorhat Press Club, Rana Goswami, the candidate of Indian National Congress from Jorhat Assembly, said that he has passed BCom examination in the year 1981 from Dibrugarh University bearing roll number such, and he claimed that he completed his BCom from JB College. The informant on query found that the mark sheet of Rana Goswami bearing registration number such, roll number such, candidate scored 25 in English, and the mark sheet showed failed against the said roll number. See, Rana Goswami has lied the people of his constituency that he has passed BCom by manipulating the mark sheet. So they are saying that I have manipulated the mark sheet. I have not enclosed any manipulated mark sheet. It was the one which I have shown your lordship, was the one which was seized from the informant, not from me. I have not produced anything. I have produced only my certificate given by the JB College for causing under 468/471, and investigation was started. During investigation, statement of witness were recorded. The mark sheet, admit copy of birth certificate, MR number such, and from the mark sheet obtained from Dibrugarh University in the case against Rana Goswami, son of late Nilakanta, is well established under 468/470. Hence, this charge sheet is filed against the accused Rana Goswami. Copies of the seizure list, mark sheet, Dibrugarh are enclosed along with a notice under 41A, and a checklist is enclosed. The witnesses column number 6 will prove the truth of the case. So the mark sheet was produced in an RTI application so-called, and they have filed it. On the other hand, I have filed that I was a bona fide student. I appeared in the examination, and my college has given the certificate to me that I had passed my exams. And in the meantime, sensing trouble may follow upon me, my lord, so I have filed a civil suit before the civil judge, Jorhat, Assam, my lord, and accordingly it was numbered as title suit number 49 of 2017, declaring the following, which I have already read, my lord, and that is available at page 44. So that being the position, my lord, if the in totality it is looked into, no case has been made out, my lord, only on due to maybe political rivalry or some getting cheap publicity, my lord, that they have filed this false case against me, which is apparent on the face of the record, because I am speaking from the record. Because the police has not gone to the college, neither collect.
Or you tell me,
My lord.
which the authority to say regarding passing or failing of one student,
First thing my college will say, my lord, results are declared in the colleges, my lord.
who conduct the examination?
My lord.
Who conduct the examination?
Dibrugarh University, under Dibrugarh University, yes.
Then who is the
They have not collected it from Dibrugarh University, anything. It is the RTI application which was given. They have collected it.
Going by the third sheet. Then
Yes.
it is like during the investigation, statement of witnesses were recorded. Page
Yes.
number 30.
My lord.
The mark sheet admit that copy of birth certificate and or
All these were seized from me, which I have
from the
already.
Dibrugarh University.
My lord, that is who gave, my lord. If your lordship will see the annexures, my lord. Let's come to page 22. 21, my lord. Twenty-one is the seizure list which was prepared at my home, my lord. Your lordship will see place of seizure, residence of Rana Goswami, Rasbari, Jorhat. And these are the description articles seized, my lord, which I have handed over. On being produced by Rana Goswami,
And going by annexure 3, can it be said that if a first of become
Annexure 3 is the RTI that they have found and endorsed it, my lord, that I was declared failed, my lord. But subsequently, in the other proceeding, I'll show, my lord, we have annexed it, my lord, what the reply came from that Dibrugarh University, my lord, in the civil suit. Hold on, second page. If a lordship will take the other one, my lord, I have annexed there how the civil case, because when I went there, they said that only documents will be submitted if there is court order.
is number?
My lord, is page is 5, it start NHO 5, page 38.
In civil revision petition,
Yes, my lord.
page number 38,
8,
annexure 5.
NHO 5. That from the side of the university concerned, it is submitted that for just decision of the case, original result sheet start stating the name of the candidate become 2 years degree course examination examined at JB College, commerce required to be called for from the university concerned. That the OP has also begs to submit that for just decision of the case, original documents like original mark sheet, original pass certificate claim to be issued by DU required to be submitted before the competent court. It is therefore prayed that the court will be pleased to admit this petition, call for the certified copy, original mark sheet, OMR sheet stating that the name of the candidate passing BCom examination of 2-year degree course examination of JB College 80 from Dibrugarh University, and to direct the petitioner to submit the original pass certificate of petitioner and original mark sheet of Rana Goswami of BCom 2 years degree course exam and all other original documents relied upon by the petitioner. Then the order is at page 42, my lord. The civil court order is at page 42, annexure 6. Petition is represented by his learned counsel. OP opposition party opposite party filed a petition by petition number 304817 under section 150 1 APC, in which OPs have submitted that for the just decision of the injunction matter, the original result sheet of BCom examination of the petitioner from JB College Jorhat of the year 80 is required to be called for from Dibrugarh University. Learned counsel for the opposite party has further submitted in the petition that for just decision of the case, original document, that is original mark sheet, birth certificate of the petitioner BCom examination of the year 80 issued by Dibrugarh University are required, and hence he has praised to call for the certified copy of the original mark sheet, OMR sheet stating regarding passing, OMR sheet stating the name of the candidate regarding passing of BCom examination in the year 80 from JB College Jorhat, and also issue direction to the petitioner to submit the original pass certificate of the petitioner an original mark sheet of the BCom examination of petitioner along with the original documents. Learned counsel for the opposite party has submitted that the aforesaid documents are very much relevant for just decision of the instant case, and the aforesaid documents are generally preserved in the strong room of the institution, that is Dibrugarh University, for safe custody. Hence, without an order of the court, the aforesaid document could not be produced from the court on their own. Learned counsel further pointed out that due to the above reason, they could not file any relevant documents on behalf of the university, and if the court has not allowed the same, then they have to argue only on the documents. Only on the documents, only, yes.
While considering the petition for crossing the FIR and search it, you have to consider the material whatever collected by the investigation. It provided that anywhere in the RPC that your documents and your evidence has to be considered at that point of time.
I have all given, my lord. Now, why should I go for the rigor, my lord? There is a civil suit pending on the same issue, and the civil courts, my lord.
Mr. Kamar,
My lord.
in Niharika infrastructure,
Niharika infrastructure.
it does benches,
No,
write down the
if there is an element of criminality, my lord, here I am having also a birth certificate. Whether that has police has not said that it is wrong. Only the mark sheet they have annexed it. And what the IO has said in the final report which they have submitted, my case has been closed by submitting a final report, my lord. That is also an outcome of that, my lord. I have come for that regarding by filing a criminal revision petition number 107 for the wrongful closure of my case, my lord.
no, that that's separate. But this petition can consider those materials.
No, it should go together because arising out of the same issue. Yes, my lord.
But different petition, two different jurisdictions.
No, my lord. This is regarding the same mark. Sorry, my lord.
Other is the division of
All thing is there, but these two are tagged together, my lord, giving outcome of the same fact in issue. So what is the fact in issue? That mark sheet, whether it is forced or I have submitted the force, that mark sheet I have not produced it. So I have not forced it. It is they who has given it by simply saying that I have not passed. On the other hand, the college is saying, no, you have passed. That is the issue before your lordship, my lord. I think so.
no, that's all right. But who is the final authority to say that you have passed or you have failed?
My lord, these documents, my lord, which I have submitted original, and these are not my documents. These were already seized from my possession by the police.
Therefore, I am asking you,
My lord.
by the Annex 30, page number 26,
Hmm.
can it be said that you have passed the exam?
No, that is their document. It is for them to say. That is, I have not to say because I have not used this document. They have procured it, they say, through RTI. What I is having is my pass certificate. What about my passing out from the college, the certificate which that the IO is silent on that. So that cannot be brushed aside. It has to be read all together, my lord. Piecemeal cannot be taken into account with all respect.
Yes. Any other point?
My lord, regarding that, I have to throw some light, my lord. The other one, my lord. This is the aspect where I have come for washing of taking cognizance of the order on the basis of the charges. Now, if
In respect of
my lord, criminal matter, because certain documents are here also, my lord, on the item, other item, my lord. If we take it together, my lord, I think your lordship can come to a conclusion. Then I'll give my final submission, my lord. In the meantime, he will also make a submission, my lord. So now what is this criminal revision for, my lord? We have filed a
there the court has taken cognizance against you.
yes, my earlier. Now this one against the final report submitted by the police that no case is made out. I have filed a case against the 4 person, my lord, which were registered as Jorat PS case number 630 of 2016 under section 120B, 171C, 197, 469, 499 IPC, my lord. Whether the closure of my case of that FIR regarding the final report number 157 filed by the opposite party number 2, that is the IO police, and the CGM issued summons to the informant to file objection, which I appeared and filed it on 16/11. I'll give the list of dates, my lord. Video. All the original documents, my lord, of the Dibrugarh University was directed to be furnished by the civil court, my lord. If your lordship will kindly look into my list of dates synopsis, it starts from page second page, it starts from serial number 5. Final report was submitted by number 1527 2017 by the OP number 2, that is the IO of the case. CGM then issued a summon to me to file my objection, which I appeared and accordingly filed. In the meantime, all the civil courts thing has started. Then IO filed a counter prosecution case against the informant petitioner under section 211 against me. Informant petitioner filed his objection against accused accepting the final report number such. So I am against the impugn order dated 17/2/2018. So there is a development also, if your lordship will see, on 9/11, 2020, Honorable High Court allowed the criminal petition earlier 38 with a direction to the learned CGM not to proceed against the accused petitioner under 211 IPC till the proceeding relating to submission of the final report is concluded after hearing the informant and considering the materials available in the case record. So accordingly, my lord, I have filed my objection to that, my lord. And why I am saying that that is bad in law, my lord? Because the IO during the course of the investigation did not verify the records lying with the JB College Jorat, neither they have seized it from the principal, which has already been furnished and reply stating that as per results, the petitioner bearing roll number 858 was declared pass. Because on the basis of the Dibrugarh University, my lord, result sheet, I was declared pass. And in the case, my lord, IO examined 3 witnesses. That is the informant of the case and 2 other witnesses of DB who issued the tabulation certificate of the mark sheet to the IO. But the IO unfortunately did not examine the informant petitioner to know his view. I don't know what will come in the case diary, but instruction was that, my lord. And why the
Yes, sir. Case diaries are available.
Yes. Here is available.
share of the type
Whether along with the here case diary,
should be, my lord, normal. Lo aho kami side দিম আছে
Okay.
I did go.
Oh,
The case that was also in FIR number 636 of 2000.
only scan copy of LCR was in the
Scan copy.
of LCR.
Whether we will not be required.
PD, my lord. Otherwise, my lord, some of the materials which are available before your lordship. PD and on the order. Your lordship may.
The case ID can be for the other days it is there.
Yes. In one.
This case ID of that is case number 636 of
Yes.
2006.
Only scan copy of PCR was called. PD was not called.
What require in the like, so suppose see the record whether it is available for
And
anyway, Mr. Kamar, you complete your argument.
My. Regarding that, my lord, if your lordship will now look into the impugned order, which is under challenge in the criminal revision, my lord. Even page 59, my lord. Dated 17/2/2018. Let us see whether that is.
Case number 59.
Yes, my lord. Well, before that, why not we look into the FIR? What was the contention in the FIR? One small glimpse, my lord. FIR contour page. Yes, my lord, I'm giving my lord. It starts from page 17, my lord. And yes, my lord. And the relevant is just page 19, my lord. It was basically a counter case regarding the same fact and issue to the officer in charge of Jorhat Police Station, Jorhat, subject FIR. With due respect, I'd like to inform you that I am a candidate of 98 Jorhat Legislative Assembly Constituency, Assam. Now, by way of forgery, the below mentioned person fabricated my educational qualification certificate as well as my mark sheet issued by the Dibrugarh University competent authority, and such kind of activities on the part of the below mentioned person is nothing but a political conspiracy through which they are trying to create some political mileage to a particular political party. That the conspiracy is committed by altering the material parts of my educational qualification certificate. They have circulated the false document among the people to underestimate my image in the eye of them. They have fabricated a certificate to be shown to the people and to the press where it is stated that I never passed BCom examination held in the year 81. The following accused have also met at a press club, Jorhat, today, and thus they have made an attempt to get the matter widely circulated on the eve of casting vote on 4th April 2016 with an intention so that damage may be irreparable and helpful for the political party to whom they support. Now for your examination and necessary action and to compare, I have enclosed here with the following documents. Marksheet old course of high school living certificate 76 bearing roll Jorhat number 925. Admit card issued by Dibrugarh University of BCom 2 years degree course examination of 80. Comments on 6th April 81. Marksheet of BCom examination issued by Dibrugarh University roll 858. That is the fact in issue. First certificate of BCom certificate issued by Jagannath Borwa College Jorhat. Result of BCom 2 years degree course examination in 1980 held in April, May 81. Now the below mentioned person have circulated among the people all the above mentioned document with the material alteration to convince the people that I am not an educated person for their political gain and to murder me politically with the help of false document, and thereby they have committed serious offense of forgery, issuing it to cause loss to the reputation. So I hereby request you to search and seize all the false documents already circulated among the people and also from the custody of the undermentioned person, and they may be arrested and prosecuted as per provisions of law. So these are the 4 persons who is the informant in the other case, my lord. They have been named as accused, my lord. So on the basis of that, police, without making a thorough investigation, my lord, have submitted my file. I filed my objection at page 47, my lord, regarding why the final report submitted by the police should not be accepted, my lord. That your lordship will find it at page 47. The informant objector has lodged an FIR on 1/4 before the Jorhat police station, alleging inter alia that the FIR named 4 accused person by forging the educational qualification certificate of the informant objector, including the mark sheet issued by the Dibrugarh University, have hatched a political conspiracy and was trying to provide political mileage to a particular political party in the eve of the assembly election of 2016. The accused person have circulated the false document among the people to underestimate the image of the informant objector, and they have shown the fabricated certificate of to the people and to the press stating that the informant objector did not pass BCom examination held in the year 81. It was also stated in the FIR that the accused person has arranged a meeting at Press Club Jorhat on the day with an attempt to get the matter widely circulated on the eve of the casting of the vote on 4/1/2026 with an intention to damage the image of the informant's objector and help the political party whom they support. Accordingly, the informant objector has requested the police to search and seize all the forged documents already circulated and those which were kept in the custody of the accused person, and to punish them as per provision of law. In support of the contention of the informant objector, the informant objector has provided all the relevant education qualification document along with the FIR. Further, after filing of the aforesaid FIR, the Jorhat police station has registered the same as Jorhat PS case number 630 under section such and such. The informant objector states that the registering the case as Jorhat PS case number Iman and such, the police started investigation of the case, and after completion of the investigation, the police submitted a final report under section 173, being final report number such dated 1611 before the Honorable Court. The informant objector states that after submission of the final report number 1527 dated by the IO of Jorhat PS case number, the Honorable Court issued notice to the informant objector, informing the informant objector that the police has submitted the final report after investigation of the Jorhat PS case 630 2016, and if he desire, he can submit objection about the acceptance of final report number such dated such on Iman by himself or by engaging an advocate before the court. And accordingly, on that day, the informant objector have submitted an application praying for time to file the objection in connection with the final report number 1527 of 17 dated Iman. Accordingly, this Honorable Court has granted time and fixed the same on 1/2/20 for filing of objection. The informant objector respectfully begs to submit that while the IO was submitting the final report before the Honorable High Court, he has also submitted a counter prosecution under section 211, and the same was registered by the Honorable Court as CR case number 176 of 2017 against the informant objector, and being agreed by both the orders dated 18/11/17 passed by the Honorable Court in CR case number 176, the informant objector filed a petition before the Honorable Guwahati High Court, which was registered and numbered as criminal petition number 338 of 2018. The Honorable Guwahati High Court, after hearing both the parties, was pleased to issue notice of motion to the state of Assam and also to Sri Golab Boilung, the IO opposite party number 2 of the case. The Honorable Guwahati High Court was pleased to state the further proceeding of the counter prosecution launched against the informant objector under section 211 IPC by this order dated 19/1/2018. That the informant states that another case between the same party is still pending for investigation arising out of the same cause of action and the same documents, which is the subject matter of both the case that is registered as Jorhat PS case number 636/2016 under section 468/471 IPC and Jorhat PS case number Iman under section Iman. The Honorable Court, by its order dated past in Jorhat PS case number such work, has observed that the investigation of the case that is Jorhat PS case number 636 is still going on, and accordingly directed the IO of Jorhat PS case number 636 to record the statement of informant immediately. Since the IO of the Jorhat PS case number 636 has not completed the investigation yet, as such no final report or such sheet has been submitted till date in Jorhat PS case number 636 before the Honorable Court. But surprisingly, on the other hand, the same police station has submitted the final report in connection with Jorhat PS case number 630, my case, under Iman, causing serious prejudice to the informant objector. So the copy of the FIR of both was enclosed. The informant state that on 18/5, the informant objector's plaintiff has filed a title suit number such before the Court of Civil Justice, praying before the court regarding that prayer portion, my lord. Be it next page, I skip, my lord. I'm not reading the same again for repetition. Be it mentioned here that the next date of the title suit is now fixed on 19/2/80 for framing of issue and document. During the investigation, the IO did not verify about the suit only before the landed Court of Civil Judge Jora, and stating in the final report that the allegation raised by the informant objector informant is false. That the informant objector most especially begs to state and submit that the final report submitted by the IO is the outcome of a defective investigation and non-application of mind of the IO during the investigation of the case, and the initial case was done in a perfunctory manner. Furthermore, the IO submitted the final report against the FIR in a very casual and mechanical manner and in a haste with a political mandate by which the petitioner has been made a scapegoat. that the informant objector states that the informant was a student of Jagannath Barua College, Jorhat, and he has passed his BCom from Dibrugarh University in the year 81. The informant objector has duly appeared for the BCom 2 years degree course examination 80, which commenced from 6/4/81, conducted by the Dibrugarh University. The controller of examination, Dibrugarh University, had issued an admit card to the informant objector for appearing on the said examination bearing roll number 858, and after due completion of the examination, the university published the result of BCom 2 years degree course by publishing a result sheet dated 11/9/81 showing the total number of candidates appeared as 1,359 and total number of pass was 1030, incorporating the roll number of all candidates who had passed the examination, including the roll number of the informant 858 as file 9 of the result sheet. So this is the Dibrugarh University result statement. I was placed at page 9. Thereafter, the controller of examination Dibrugarh University issued a mark sheet to the informant objector showing the detailed marks secured by him in all papers, including the marks for paper English 21 and internal assessment 9, and the total being 30, and the result has been mentioned as passed. Therefore, JB Law College issued a provisional pass certificate to the informant objector on 26/9/81, certifying that the informant objector has passed the BCom 2 years examination from their college under roll number such 858 in pass course with the subject mentioned therein. It will not be out of context to make herein that on a reply furnished by JB College Jorhat in response to a legal notice dated such issued on the instruction of the informant objector, the said JB College Jorhat in his reply dated 34 has clearly stated that the result of a BCom examination held in 1980 was declared in 1981 as per result sheet. Rana Goswami bearing LO was declared passed. The IO of the case also did not verify the records.
Where is the mark sheet you have to here?
Which mark sheet, my lord?
Your mark sheet?
My lord, that mark sheet is the one which they have seized it. I have enclosed it. Now, right now, I am enclosing all the documents that is relying by the prosecution, my lord.
No, no.
This one, then I have to contact my client to know it, man. But I don't think I have annexed it here.
That you have enclosed the mark sheet here.
Which one, my lord?
Enclose the mark sheet given to you by the university.
University, my lord. That is, I have to. Will I do? In the other one, my lord. Other case, to first one. My lord, 25, my lord.
Page number 25.
Yes, my lord. Click on it. Click on
25, number 25 is the copy of search sheet.
No, my lord. In the other case, my lord, that is criminal petition 74.
Page number 25.
Yes, my lord. Your lordship has queried my mark sheet, my lord, which I have given, my lord. English to go to group A. My lord, your lordship will find it at group A. Because rest there is no dispute, my lord. RTI only that English part is disputed, my lord. Your lordship is that is coming in group A, my lord. English. In RTI it is shown 16F. Internal assessment 9, total fail. And in the mark sheet, it is 20.
One of them.
Yes, any other point?
Well, there are, my lord. Now, actually, we'll have to look into this, my lord. Now, my lord, till annexure 5 have used it. Rest your lordship can also go through it, my lord. Now, the main contention is that whether the acceptance of the FIR is in accordance with law, whether the order that has been passed on 17/12/2018 is a valid and legal order or not, whether there is any palpably wrong thing in it. If your lordship will kindly permit me, it's a one-page order, page 59, annexure 9. In that revision, my lord, this order is under challenge. I read, my lord.
Page number?
59, last page of the my revision petition, my lord, wherein I'm agree with the order, impugn order dated 17/2/2018 regarding acceptance of my final report in my case. I have filed the FIR against him, my lord. The final report was submitted, my lord.
Yes.
So on that basis, order was passed. That is the order under challenge before your lordship. Today is fixed for necessary order and on the objection of the informant of acceptance of the FIR. I have meticulously perused the objection of the informant and also the case diary and the documents of this case. Case is registered under such sections are there, and the allegation against the accused person are that they have forged the documents showing he never passed BCom examination from Dibrugarh University. So I don't know how this Honorable JFMC has come to this finding. He never passed the BCom. The contention was in the RTI was that I have not passed in my English from Dibrugarh University. It is further alleged the informant that the reputation has been harmed by the accused in front of the people, ruining his political career. The IO investigated the case and accordingly, and it appears from the case diary that the IO examined the informant with two other witnesses of Dibrugarh University, total 3. No, they have not examined the accused also in this case as it transpires. Dibrugarh University who issued him the tabulation certificate of mark sheet of BCom of the informant. It is found in the case diary that the IO, after matching the tabulation certificate with the original mark sheet of the information, found discrepancy in the numbers of mark, and he also found that the informant had never applied for provisional birth certificate from the Dibrugarh University. So provisional certificate will come only just because his apprehension is that I have not applied for provisional certificate. Provisional certificate, with all respect, your lordship, everybody knows, is a temporary thing, only to get things done within the period of coming of the final. Since I have already got it, my lord, so I have not applied for the provisional. So can there be fault on that part that I have not applied for the provisional certificate? So suspect arises. Never applied for provisional certificate from the DU as he did not pass the BCom examination. On the other hand, it also appears from the case diary that the accused has collected the information against the informant through RTI at Dibrugarh, and there is no chance of manipulation of the documents against the informant. How can that be, my lord? Anybody can manipulate any documents at any point of time. There is no finding to that effect that whether that RTI is a manipulated document or is not a manipulated document. There must be a finding to that. I have therefore found the investigation to be proper and is of the view that the investigation does not require interference of this court. Accordingly, I have accept the FIR so filed by the IO against the accused person. Case stands disposed of. So without any causes, reasons, finding, and I now would like to show how wrong the There is no finding from the IO that my BCom first certificate is a false one. He has, whether he has gone to the JB college to verify it, who has finally issued me the certificates, my lord.
No, there is a finding of the trial court that the IO investigated this case according, and it appears the case study that the IO has examined the informant.
Yes, my lord. My instruction was that he never came, my lord. My instruction by my client was that IO never contacted me. That's why I said your lordship will send that diary, my lord. My instruction was that I've stated. If the IO has on his own written it, I also don't know.
And I will go through it. I will go through it, man. I will correct mark, I will go through it. Regarding in 636, 630.
The IO might have written on his own also, we don't know. That is another aspect of it. Nobody objection কোনো থাকেনি object এখানটা objection কোনো আমি যে objection ফাইল করছি ক্রিমিনাল রিভিশন কোনো না তাও কি হবে কপি হৰাই গৈছে
লাগিব নেকি?
না মোৰখন আছে ইহঁতৰ পৰা মই যে objection ফাইল কৰিছিলো তাতে এই বিষয়ে লিখি গোটেইখন পঢ়ি লাভ নাই আইও আমাক এক্সামিন কৰাৰ বিষয়ে ইয়াতে কি লিখি সেই পইণ্টটো চাব ইনষ্ট্ৰাকশ্যন পেটিশ্যন মতে নট এক্সামিন বুলি কৈছোঁ Well, the IO ought to have seized the documents. If he has asked me, I would have given him my other documents also, my lord.
Statement is there.
My lord.
Your statement is there in the case.
I was told that way. The police never came, never contacted him, and took his any certificate from him. Where is your past certificate? Because I have said something, my lord. That is as per instruction. I have stated that. And
Because you are not supposed to put your signature in
my lord, that is always there.
recorded by police.
No,
You cannot
fine, my lord. Now let us come to the attending circumstance. Was it not the duty of the IO to ask for the document on the basis of which I have filed the FIR and seize them? What type of investigation will it be, my lord? He is the man who, as investor, he is the judge. He is opining everything, my lord. So was it not a duty cast on the IO to ask for the documents?
IO has collected it from the information.
My lord. No, my documents with the JB college gave it to me. From where I am saying I have passed it.
That document.
He has only compared with the tabulation sheet, my lord.
That document is also available there.
May be available, but what about your lordship is asking that my statement. So in that, my lord, they should have asked me, give us the documents. I don't know what is the statement, my lord, but I think it was the duty of the IO to collect the documents. Have asked me. Whether they have asked me, it was the duty without doing documents. What type of investigation he has done, my lord? I am the informant of this case. As an informant, They should have examined me, my lord, asked for the documents, my lord. Because this is a separate proceeding altogether.
Okay.
My lord.
Any other point?
My lord, I'm just coming. CGM failed to take the objection filed by the informant in his proper perspective. I've written a synopsis also, my lord, in the thing, my lord. Then the title suit is pending. Title suit is also pending before the learned civil judge. I'm just pointing it out in my objection. I have mentioned it at page 54, para 9, that I have the said case has never contacted him and neither approached him to know about that fact. He's part of the fact, my lord. That also I have mentioned in my earlier objection, not for the first time I have taken. Then the title suit, which was renumbered subsequently, my lord, for determining the genuineness of the document is already pending, my lord. And for that, I have got a judgment from the Honorable Supreme Court, my lord. Supreme Court ruling. Shanti Kumar Pandya versus Sukuntala Devi, my lord. Paragraph 15. It is well settled law that a decision by a criminal court does not bind the civil court, while a decision of a civil court binds the criminal court. Para 15. I've just read the relevant portion, quoting it from Sarkar's evidence. And
It's in a different context, but
of course, my all judgments are in different context, but what is the principle of law, my lord? That is what I'm saying, my lord. No facts is alike, my lord. No criminal case will be alike.
No,
It is only the principle, the ratio, my lord.
sir, Amar,
My lord.
the civil case is yet to be disposed of.
Yes, my lord. It is in what stage, I don't know. Evidence stage, my lord.
Then can we sit over this matter till disposal of the?
No, your lordship can definitely, but see, my lord, one thing is there. It cannot be sacrificed at the altar that you must go to gallows. If it the law permits, then your lordship will have to accept it, my lord. My all respectful submission with humble hand, folded hands, I'm praying that.
No, they clearly submit whether we will wait till this.
Yes, my lord, that can be waited. Let the final conclusion come. They will decide everything, my lord. That is the issue, my lord.
And whether this decision will help you. This is the.
No, that is what the ratio has been laid down, my lord. But
It's distinguishable.
no, your lordship, we can also distinguish in our manner, my lord. Ultimately, what your lordship will say, we are all have to respect it, my lord. That is there. But the law that has been propounded by this honorable Supreme Court is that.
No, that's all right, but
my lord.
that has to be.
No, now it's a civil court. So your lordship can direct for expedience or day-to-day hearing can take place and dispose it of. The civil case. Civil case may be directed to be disposed of at the earliest.
No, that is not the issue before the court. How can we direct?
Then we'll have to wait for it because
of the Supreme Court,
the person, my lord, is before your lordship coming with certain proposition, my lord. Whether that proposition is supported by the legal evidence.
Therefore, I am asking you
Yes, my
whether this will help you.
but definitely.
This is in
My lord, let the civil court decide, my lord. If I am wrong, then I have to be punished, my lord. Ultimately, we are not with the criminal. We are with the person who has come innocently claiming equity before from your lordship. Justice from your lordship. If he is guilty, definitely he will face the consequence of law, my lord. Because ultimately, your lordship, two things are emerging on the same time. One is, my lord, that one RTI tabulation comes wherein I am shown failed in English. And on the other hand, I have a mark sheet where I am shown this. And the civil court it is in seized with the matter. And my complaint was whimsically dismissed because of the fact that the suspect of the IO is that I have not asked for provisional certificate. That means I have not passed. Can that be an assumption, my lord, to hold a person guilty of forgery? In the order sheet, if your lordship will,
Trial has yet to be started to examine that issue.
no, if your lordship thinks that way, I have got nothing to say. By my contention, I have put in my written submission, my lord. I like to place it because JB Law College, sorry, JB College has also given a pass certificate, my lord, and I'm possessing that.
Mr. Kapar, that is
My
a
lord.
matter of trial. Whether you have forged the document or not, the court will say.
No,
Trial court.
on the face of the record, now the Supreme Court has come up very recently within this
This
week
court is
that
not
there were
entitled
4 steps to be complied with. And one of it is this: if my document is of sterling quality and it inspires truthfulness, then your lordship can look into. I could not lay hold of the judgment, my lord, but I have read it on the news live.
Whether that could be considered in case of the petition under section 484.
Yes, 482. 482. The Honorable Supreme Court
What is the
recently,
strength of the bench?
my lord,
What was the strength of the bench?
2 bench, my lord.
Two bench. Here it is 3 judge bench.
My lord, that Pandya's case, my lord. I am not producing that document. I am producing that document the police have deliberately not seized in my case. Why? Why my documents was not seized? Why my documents was not asked for? Why INA has? Recently, we have read it in the live law, my lord. Supreme Court had laid down the steps to be considered by the High Court while hearing a quashing petition under Section 482. The following steps should be ordinarily determine the veracity of a prayer for quashing raised by the accused invoking the power. Step 1, whether the material relief upon the accused is sound, reasonable, and indubitable. There is a material is of sterling and impeachable quality. I've also not done it, but in the news live it has come. I'll have to find it out, my lord. My lord, somebody comes and says something, my lord, that cannot be taken as face value. On the whole context, it has to be looked into, my lord. There it has not come. There, no, I have not produced that mark sheet, my lord. I have produced my document. Whether my document is false or fake is not coming. They are showing a document of their own saying that I have not passed. That is not in totality, my lord. Because the materials in totality, it should become, my lord. For that, I have given the written synopsis, my lord, on the points basis, 12 points I have mentioned in it, my lord.
Dev Chaudhary.
On 14 of October at 2 p.m. The
14, no, 13.
April of 30th is 36 of 16.
Well, can it be on 15, my lord, please, your lord?
Wednesday, yes.
On 15, my lord.
No, no.
Then on 16?
Okay, 16.
Because I'll be out of station, then come. Well, only my contention of the law points I'll submit it, my lord. On, oh, yes, my lord. Much obliged, my lord. কপিখন দিয়া আমার লাগে যদি দেখা দিয়ে একটু খুলি
May this please your lordship. I'm appearing on behalf of U. Sharma. Your lordship, it was in the personal department offers your lordship for opinion solution, your lordship, and it was under the personal department. The file has sent to personal department on the dated 6/6/2025. I would like to place it on the record. যাও হেৰিটো personal তাত গৈছে
May I please also, on the last occasion, Lordship, I directed the S code Lordship to obtain instruction from the personal department. Lordship. I have received the SOP place কৰিব নিয়ে next এখন
On next SOP.
What the SOP was it?
Yes, I have listened.
Yeah.
30 August Lordship recently Lord. As per this SOP Lordship, the matters pending, all the matters Lordship pending for compassionate appointment is consideration by the personal department for verification of the entire document.
Delay. আপোনাৰখন মই গৈছো।
Lordship, direction was clear, Lordship. Direction was to select the petitioner for get three post, election her overall. So there is no Lordship other consideration. Lordship. So they have to relax my age and then to place before the SLC, Lordship.
SOP this.
SLC. But the overriding the order, Lordship, they are passing some orders.
No. Order of this court.
Lordship, can we page 62, Lordship, paragraph 16
And operative portion is?
of my contempt petition, Lordship. Paragraph 15, considering the provision laid down in office memo number so and so, noted about the implementation of the state level committee for completion upon rejecting the case of the petitioner for a compassionate appointment in terms of office memorandum in a meeting held on 4/1/20 on the ground of overage and underqualified for the post of assistant hereby set aside was. The secretary to the government of Assam in the Department of School Education shall place the case of petitioner before the next meeting of the SLC for compassionate appointment appraised for her compassionate appointment, considering her eligibility in any grade
Yes,
post.
okay, the direction also place the matter before the SLC.
Oh.
Appraised.
For her compassionate appointment.
And
Considering her eligibility in grade
all
three
the
post.
pending matters will be taken up or will be placed
Yes,
before the
Lordship. Yes, Lord. As per Lordship direction of this honorable court, Lordship. In 342, Lordship, that into as per direction of the writ petition, Lordship, in 342 2025, Lordship, all the pending cases are now considered.
So they cannot club together with other orders, Lordship, of my writ petition, Lordship, of my order, Lordship. As because petitioner case is clear, Lordship.
No, direction was to place the matter before the SLC.
SLC.
As per this SOP, they will be placing the matter before the SLC.
And Lord,
And that will, thereby they will comply with the order.
Right.
If the SLC take a decision otherwise, then you have to select that decision.
What is my the submission is that there a letter, but considering even get three post of master degree, relaxing her overall. There is already order from the court, Lordship, to relax the overall.
To
Last
place the
line,
matter
Lordship,
before the SLC.
appraised for her compassion, considering her eligibility in grade three post, being a master degree in Assamese, relaxing her overage at the time of application for compassion development. So there is already order, Lordship, to relax her overage, Lordship. So in some cases,
Who will relax it? Who will relax it?
department, Lordship,
Personal
concerned department, Lordship,
Direction was to place the matter before the SLC.
SLC.
Lordship. SLC, letter for Lordship, SLC for compassion development appraised for her compassion development.
SLC will consider it.
SLC.
Considering her
It will place on the next.
1 minute. Considering her eligibility in get three post being master degree in Assamese, relaxing her overage, Lordship.
They will consider it.
Lordship. So there is but one order has been passed by the respondent that they cannot consider the case of the petitioner lordship. He has overridden the order passed by this honorable court lordship.
No, no. Now they have decided to place it before the SLC. That is the instruction given by the personal department. Education.
Actually, now what he has submitted before the court, I am not aware, lordship, of my learned friend, what is submitted before the, I am not. Yes, in it. Okay, yes, I keep submit.
Lordship, in the last page, lordship, there is a lordship format, lordship, and the petitioner is lordship submit the form details, lordship, before on or before lordship 15th of May, lordship, on Monday, lordship, next Monday, lordship. In the personnel department, lordship.
What is dated 30th August?
Yes, in last page.
Lordship, my commission is that the government of when issued the SOP. If they issued the SOP after passing the order by this honorable, that will normally not affect my case, lordship. When issued the SOP?
We want to place all the pending matters to the SLC.
SLC or DLC, lordship?
Yeah.
Yes, lordship.
Lordship, that is issued as for earlier order that was issued on 31/3/2017.
No,
No.
it's a recent SOP.
It is issued on like when is it? 28/9/2024. 28/9/2024, Lordship. This SOP.
Pardon?
What we want to place before the food, Lordship, that SOP was issued on 18/9/24.
No. Recent SOP is 13.
When issued your SOP? You have not mentioned your date in the letter.
30 August 2025.
In this, Lordship, there is no resolution regarding some of the commission that the government of Assam has issued an SOP and the Department of transaction telling the guidelines on not
It is last page. Notice.
Lordship.
What format is provided, and you have to apply in that format.
Yes.
As per this SOP.
Or fresh.
Sorry, Lordship.
Do not follow.
Lordship.
I'll furnish him the notice and the
Lordship, what is this letter, Lordship? This by this letter, they have said that the so regarding appointment of commissioner government of Assam has issued an SOP.
Yes.
When Lordship issued SOP, this is not mentioned. And the Department of School Education is requested necessary following the guidelines mentioned SOP if I do endorsement number so. So my grievance is that, Lordship, my submission is that since the honorable court directed to place the Lordship to SLC.
They have decided to place the matter to the SLC.
Lordship.
And they have also issued an SOP. As per that SOP, you have to apply one format that is given in this SOP. Last page.
I have not furnished that, Lordship.
You please go through the same. You let this court know after some time.
Lordship, can you please pick
No,
up?
if we adjourn the matter, you will miss the last. Because 15 is the last.
Short
day.
it
15 is the last.
or lordship
More than
pending the lordship contempt that lordship you will in this by this time you will apply lordship.
apply.
So if 15 is they have to submit before the court, they have to furnish the copy to me, Lordship. So I have not informed Lordship.
Furnish.
So if 15 is the last day, they have now stated before the court.
আজি আহিলে বুলিহে নহা হ'ল
The petitioner is lucky lordship that
lucky enough your lordship before 15 this
Yes.
matter has came
otherwise he missed the bus.
photo mari log
ফটো মাৰি লৈ যাওক
কপি দি গলো ফটো মাৰি লৈ গলো।
এটাই ফটো দিব লাগিব ফটো মাৰি লওঁতে নহ'লে ফটো মাৰোতে তুমি মোক ফোন নাম্বাৰটো দিয়া তোমাৰ মোবাইল
Please, your lordship. Here, my lord, these petitioners before your lordship for similar relief, lordship has already been extended in the similar situation with other person. That order, lordship will find at page 75. This is lordship's order. One five 2025, lordship has passed this order. In this order, my lord, page 82, from that paragraph 8, it is started for the relevant portion.
That's a poster like that. Yeah.
Yes, my lord. Yes, my lord. Already they have filed an affidavit.
Some post was sanctioned, my lord, and out of that I have given the details, my lord. In page
120, lordship, of his additional
120,
affidavit.
my lord. Subject-wise vacancies, my lord, in different polytechnics.
For what?
Subject-wise, this mechanical engineering, electrical engineering,
Page number?
page 120, my lord, in my additional affidavit.
Altogether 16 books are there.
Yes, my lord.
And the petitioners are of which department?
In
Mechanical, electrical, my lord.
in this case, mechanical, electrical, mechanical engineering, my lord.
Petitioners are there.
My lord, there is two petitions, my lord. Four petitioners, my lord. In the first petition, item number 17, mechanical engineering and civil engineering, my lord. And civil engineering is not available here.
Civil engineering, not no vacancy, my lord.
And another case, my lord, both are electrical engineering. But this is the
In this petition, 2651.
Yes,
Item
lordship.
number 17.
Here.
They are belonging to which department?
Petitioner number 1 belongs to civil department, civil engineering
Civil is
department.
not there.
It is not there. And another is mechanical engineering, my lord.
So mechanical is there.
Yes, there. Four posts is laying vacant.
Mechanical for
And but here, my lord, our arrangement is a purely temporary arrangement, my lord. Purely temporary arrangement, my
so
lord.
if posts are not there, then where you will be posted?
Yes, my lord, that is the problem, my lord. In another case, my lord, both are phone number to na. Bolta. Phone number to. Phone number to.
So Borua,
Yes, lordship.
this petition one Dibayan Kaur
For
and
he
Gaurav
is
Bhanik, they are the petitioner.
petitioner, my lord.
Then which one is belonging to mechanical part?
Mechanical department is
Petition number 2 is
the
the
mechanical engineering.
Petitioner number 2.
Two, yes, lordship. That is lordship will file at page 26 my degree certificate mechanical engineering. Page 26, page 26 annexer 2. This is my pass certificate, my lord, issued by the university. Mechanical engineering and was placed in the first class. Last line. And my lord, I was appointed as a mechanical engineer.
Sir, does so far. Is there any objection? Granting similar or
My lord, my only objection is that, my lord,
My lord, sorry, my lord, kindly give a look in paragraph 3, my lord, of the additional affidavit filed by tomorrow.
tomorrow,
No.
Nine.
Nine. 9, my lord. Paragraph 3 of his additional affidavit, my lord.
in respect to that particular annexure, my lord. The deponent begs to state that in various polytechnics of Assam, as on 1/9/2025, there are 16 vacant sanction posts to be filled up by through a direct recruitment process. The publication of advertisement for filling up the said vacant post through the Assam Engineering Service Recruitment Board is under process. My lord, that means till date, my lord, no advertisement has been published. And my lord, the duration of our service is only for 4 months. My lord. And publication of advertisement yet to be done. That is the statement, my lord, at paragraph 3, and that has been supported by that annexure 2, page 120, my lord.
What is your topic?
My objection is, my lord, it is a policy decision of the government to engage the my lord, persons under 3F, my lord. And pursuant to that cabinet decision, 100 numbers of candidate has been engaged in 3F, my lord. That is in page number 69 of the writ petition, my lord. That pursuant to cabinet decision, 100 numbers of candidates has been engaged under 3F. Now, my lord, as per the policy decision only, all the 3F candidate has been, my lord, terminated. Now, this 3F arrangement is nowhere there. Nobody is engaged under 3F now, my lord. This that's why, my lord.
Posts are lying vacant.
Yes, my lord. For posts are lying vacant, my lord. But the thing is that since my humble submission is, my lord, that since
Entitled to two extensions.
Lordship,
They are entitled to two extensions.
two extension now, my lord, we have not been given the first opportunity, my lord.
their case is
The
that, my
extension is coming later on, my lord. First time, my lord, we have to be appointed, my lord. Out of the 257, my lord, they have appointed, my lord, only 100. We have been denied. And similar situated other person before your lordship, they have filed a case and the lordship has passed the order. What he has submitted just now, my lord, in this regard, lordship has already been replied at paragraph 11, my lord, at page 82 of my writ petition.
Okay, they want that similar orders to be passed.
Yes, my lord. Yes, my lord. My lord, kindly give a look at page para 11 of lordship's order. That has already been replied.
And in other petition,
Other petition, my lord, their posts are available, my lord. Electrical engineering, both. Two petitioners, my lord.
My lord, my humble submission, my lord, is that my submission will be on that this order, my lord, will not be applicable here because at that relevant point of time, 3F appointment was not cancelled, my lord. They were there. Now, my lord, all the 3F appointees has been terminated pursuant to, my lord, because that was arrangement of a cabinet decision, policy decision, my lord, and all the 3F appointees has been terminated now. So even if there are vacancies available with the government, my lord, they cannot be my lord, adjusted in 3F, which is not there as of now, my lord. The policy, my lord.
At that time, my lord, we have not been considered, my lord.
So, my lord,
While the
for-
100 were
for-
considered,
for
that is our case.
For that, my lord, remedy is available.
Oblige, your lord.
Actually.
May I please, your lordship, members? My lord, just 2 days back, my lord, this case was listed and I have received the, my lord, affidavit in opposition filed by the director, my lord. Wherein, my lord, it has been stated that on the day of inquiry, as regards my school, my lord, they could not meet, my lord, anyone, my lord. And I admitted that on the day of, my lord, inspection, my lord, we had to remain absent, my lord, because of sudden death of one of our relative, my lord. And regarding this, my lord, inquiry, my lord, they have also admitted that no prior notice was served, my lord. Anyway, my lord, the crux of the matter is, my lord, different, my lord. The impugn order that has been put to challenge is the, my lord, by virtue of, my lord, order dated, my lord, 28th of April in page 97, annexure 24, that has been put to challenge, my lord. And in that particular order, my lord, lordship will find at page 99, last page of the writ petition, my lord. The concerned director has said that no enrollment on the UDIS code in the database maintained by NUPIA for the year 2016 and 17, my lord. And in this regard, my lord, I want to draw your lordship's attention again, my lord, as regards the, my lord, inspection report which was passed by the SIV schools, my lord, page 84, annexure 18, my lord. For a moment, lordship will kindly come to page 84, my lord. My lord, this is an inspection report which was conducted on 5th of May 2017, pertaining to the year 2017, my lord. And the number of students present, my lord, on that particular day, if we count it, my lord, it becomes 116 total, my lord. Therefore, my lord, the findings, my lord, on the basis of which my claim for provincialization of service was rejected, my lord, that is not sustainable in the eye of law, my lord. And regarding the Dias code, my lord, that I have already, my lord, clarified, my lord, that because of the, my lord, dispute between two schools, my lord, the Dias code pertaining to the year 2009, my lord, which was in my favor, my lord, that was not released, neither that was, my lord, issued afresh. That your lordship will find at page 96, my lord, annexure 23, my lord. Annexure 23, page 96. This is a communication made by the, my lord, DEO, come district mission coordinator. This was made to the mission director, Sarva Shiksha Abhiyan, my lord. In the last paragraph, my lord, it has been stated that Dias code may either be renewed or issue a fresh Dias code to the school headed by Muhammad Azizul Haq. He is the petitioner, my lord. This was made on, my lord, 31st of March, my lord, 2017, my lord. So apparently it is very clear. And regarding the earlier dispute, my lord, lordship will find the speaking order, my lord. Everything has been discussed elaborately, my lord. Page 76, my lord, I'm sorry. Annexure 15, my lord. Page 76 is the speaking order. And because of the dispute between two schools, my lord, my schools could not be provincialized, my lord. And the lordship had directed me to produce the, my lord, other applications, my lord, regarding issuance of the Dias code. And I had, my lord, produced the continuously the, my lord, applications before that may be part of case record, my lord, in the file probably, my lord. Right from there, 2011, my lord, I submitted the application before the concerned authorities, my lord. That is in the, my lord, main file of the, my lord, petition, my lord.
So, Gopal, what is your step?
Lordship, we have filed two affidavits, my lord. One is we have filed for the secretary, my lord. Whereas, my lord, and the stand of the director, I had taken time last time, my lord. The director has also given that, my lord, when the inquiry was made, my lord, because there was a dearth of joint director rank officer and an additional director at that point of time. So the deputy secretary, my lord, which will come at page 102 of the affidavit, an opposition filed by the secretary of the department.
The additional
And my lord, 103. Paragraph 2, my lord. The deputy secretary was deputed, my lord, and she accordingly she went as per the order dated 7/11/23, my lord. The lordship 7/11/23, my lord. The Miss the Spencer went, my lord, with regards to the claim in regard to the claim of the petitioner for provincialization of so and so, Dakshini Kadamuni Pathar VLP school located at so and so. It is specifically in category to state that the inspection was carried out on 29/1/24 at 10 a.m. in working day. On spot inquiry, it was found that the school in question is a kacha house and the walls of the pillars are made of bamboo with a single room. There is no teacher and student found present attending this class during the class hour. Be that as it may, there is no one present during class hours, either of the teacher or student in the school premises. Therefore, the proceeding books and other documents relating to enrollment could not be verified. The basic needs of the school are not available. Even there is no environment for learning of students, my lord. So specific this thing was made, my lord. They went and checked, my lord, and they saw that there is no school, there is nothing going on there. And my lord, if your lordship checks the order dated 7/11/23 once, that, based on that order, I think, my lord, they had gone, my lord. No, lord, 7/11. Just kindly see 7/11/23 order in this petition itself.
7/11. Then
So paragraph 5, your lordship will see of that particular order. The inquiry was asked to be made.
Lordship,
Paragraph 5. Lordship, paragraph 5 of the order of 7/11/23. There, my lord, if lordship allows me to read it, the court is compelled to pass the order as indicated above so as to enable the director of elementary education Assam to conduct an inquiry with regard to the enrollment and condition of the school of the petitioner so as to communicate the same to the court. This affidavit has been filed, my lord, the previous one. And my lord, they have when the inquiry was conducted, it seems that there was no school present, my lord. And even when he has said today, my lord, that some person has died, my lord, it is the duty of the teachers there to inform, my lord. They just can't, my lord, just close down the school suddenly like that, my lord. There are steps and procedures, my lord, to be to conduct this thing a school, my lord. So, my lord, the school itself is not there, my lord. So, Lordship will see at page 103 of the affidavit, my lord. Additional affidavit, sir. Additional affidavit. This is the inquiry the deputy director has made, along with the deputy secretary.
So
it's a
these
fish.
photographs are part of the report.
Photographs, my lord, we have not annexed, my lord, here. He himself has admitted he was not there. He has himself admitted that he is not there. With me, my lord. The first one. My lord, should be referring to which page, my lord? Which page of page number 1?
It's on the record.
My lord.
it is not in the record. Not in the record. My lord will kindly also go to the.
That is not on record, I think, my lord.
My lord, lordship will make a specific observation on.
It's there, my lord. Okay, last time it has been my lord must have been submitted by some other councilman.
My lord also made an observation, my lord, on 13th of my lord, March, my lord, 2025, my lord, that whether any prior notice was issued or not, my lord. Lordship will kindly have a look on order dated 13th of my lord, March 13/3/2025. They said they could not answer it, my lord.
Oh, yes, yes.
13/3/2025.
The photograph was not annexed in the affidavit, but it was, I think, last time produced before the court by the previous council who had appeared, the standing council. So their photograph has been shown, my lord, that no one is there. Nobody is there in the school. And that itself shows, my lord, the report shows that there is nobody was attended the school. It is a kacha ghar, my lord.
Maybe.
So, my lord, kacha ghar and it cannot maybe, my lord. It is not a proper school, my lord. It is a distinct school, my lord. So, therefore, my lord, it's a fit case for dismissal, my lord. This case.
I'm submitting before a lordship. Lordship will
Fit
kindly allow me
case
5
for
minutes.
dismissal, my lord.
My
My lord. It's a fit case for dismissal, my lord, because the inquiry report, as directed by the honorable court on 7/11, my lord, was done later, and my lord, that report is before your lordship. Plus, an affidavit has been filed where, on oath, the deputy director and the deputy secretary has said that the school was nobody was present in the school. There's no students also present. There was no teacher, and now he's giving oral submissions that he was not present because somebody had died there. These are all. So, lordship will take into consideration all these aspects, and my lord will dismiss this petition. That is my humble prayer.
Yes. May I submit before a lordship, my lord? Lordship, regarding this inquiry report, my lord had made a categorical statement and clear-cut observation in order dated, my lord, 13th of March, my lord, 2025. Lordship will kindly have a look. A specific direction was given to the concerned department whether any prior notice was issued to them, the petitioner or not, my lord. They could not answer it. Now, by way of, my lord, filing an affidavit in opposition, which I received, my lord, just day before yesterday, my lord, they said that there was no prior notice which was ever served upon the petitioner, my lord. And the ground of rejection is absolutely different. Absolutely different, my lord. Lordship will kindly have a look again. I'll take your lordship to, my lord, last page of the petition, my lord. The ground of rejection is, my lord, there was no enrollment in the school in the year 2016 and 17. And, my lord, regarding that aspect, my lord, I have already, my lord, drawn the attention of your lordship to page 84, my lord. This is an inspection report, my lord. This was never disputed by them. Neither it has been stated that this is a false report, my lord. The inspection report, my lord, pertaining to the year 2017, it says that my school had, my lord, the enrollment of total 116 number of students, my lord. This was never disputed by them, my lord. And regarding the, my lord, Dias code, my lord, I have already placed before your lordship, my lord, every year, my lord, I made a categorical, my lord, statement in by way of, my lord, several applications, my lord. And that has been placed before your lordship. And one of the application has been also, my lord, annexed in the writ petition also, pertaining to the year 2015, my lord. Now they are saying that merely by conducting an inquiry, my lord, on the day I have been repeatedly, my lord,
Not nearly that inquiry was conducted.
inquiry was conducted and on the day of, my lord, and that inquiry, my lord, I have been submitting, my lord, before your lordship that I remained absent. The school is run by 2 teachers only, my lord. I along with another teacher, my lord. And on the day of, my lord, that particular inquiry, my lord.
The photograph.
Yes, my lord.
Can you please say to the what's the next outside?
The school was at venture stage, my lord. The school is in venture stage. This is the difficulty, my lord. They did not receive the, my lord, in fact, the financial assistance.
He said that in that school there is enrollment of 160.
That was there, my lord, in the 2017, my lord. Not this is a, my lord, recent photograph. My lord. The water is also, my lord, seen, my lord. This was, my lord, the recent photograph, my lord, and the inquiry was carried out in the 2017, my lord. Anyway, my lord, on the basis of, my lord, the observations made by the, my lord, specific observation made by the director, my lord, it has been held that, my lord, because of not having the, my lord, required number of students, my lord, the school could not be provincialized. If we go by the inspection report, my lord, page 84, submitted by the, my lord, SI of schools, this was never disputed by them, my lord. They were supposed to file a detailed, my lord, affidavit, but, my lord, they have only, my lord, stated that regarding the inquiry report, my lord, nothing has been stated. They have never disputed, my lord, this particular inspection report. Or she will kindly make an observation, my lord, that at least one chance should be given for reconsideration of the, my lord, provincialization of the service of the petitioners. That is my humble submission before your lordship. Otherwise, my lord, this man is, my lord, suffering since 2013, my lord. There were, my lord, several round of litigations, my lord, right from the 2013, my lord.
Order to give process to you, we have to set aside the
Yes, please.
order.
Yes.
But where is the material?
The material is, my lord, this inspection report, my lord. This was never disputed by them. They never said that this is a false report,
That is
wrong
the
report.
year
17.
But there is this inspection report speak otherwise.
But on the basis of 17, my lord, the enrollment position of the school, my lord, for the year 2017, my claim was rejected, my lord, for provincialization of service, my lord. Therefore, my lord, I have already placed, my lord, the inspection report, my lord. Now, she will kindly consider that part, my lord.
How much?
Respond number 1, 2, and 6.
Or 3.
Is the matter on Thursday for further?
Yep.
Your Lordship, may I please, Your Lordship? The matter may be adjourned for the day as Mr. Kyal will not be able to appear today. Lordship. For personal difficulty.
Arrears for the of means
R. Hussain, Your Lordship, on behalf of Mr. S. C. Kell.
everyone on behalf of the okay, like the court premises or when
18th September.
That is next.
so I have gone through the document.
Lordship, I have got, in this notice, Lordship, at para 10, clause 10, stated the date of filing of the court case challenging the office memorandum dated 18/9/2021 and disposed the High Court Honorable Court. But I have not challenged this order. I have the earlier grievances, Lordship. I may be allowed to put my order in this clause.
Yes, but he finds the case number, Lordship. Petition and contempt case number is 32.
Then we can close this petition.
No, Lordship, matter may be also pending, as because what they will take the action on my application if I would file. Lordship,
What I say, direction of this court to place the matter again before the assembly.
yes, sir.
And they have decided to place the matter assembly.
Lordship.
No.
Then
Lordship,
what is there?
as per earlier, the information submitted before the court, the SLC directed the respondent to take the view from the personal limit, then again place the before the SLC, Lordship. But he has
Now
not,
they will place the matter before the assembly.
Lordship. So my humble prayer, Lordship, petition may be pending, Lordship.
Or or number?
No, Lordship.
You are not contempt.
Not.
You are appearing for the department or order of the date and specified. Obtain personal obtain facts from the personal department or that the department or requested the department specific guidelines to write endorsement in E file number 5. And producing the SOP by the government or also something that the government has taken a decision that all the pending matters the concern DLC and SLC. And then also each one of these that is by application. The petitioners with some documents from the state of that the petitioner also the petition following with the document of the stated according to the file application that all the oh, it is the both of the this is the method as ordered after which file the
May I please, Your Lordship. Sir, kindly see the last order, my lord. Mr. U. Sharma was directed, my lord, to bring status or instruction. my lord.
every
Lordship, on earlier occasion, Your Lordship, I furnished my communication. Your Lordship instructed my colleague U. Sharma to have the necessary instruction upon that particular communication. Advocate U. Sharma. It was recorded in the last earlier order, last order.
He is out of station, Your
silence.
Lordship. Kindly matter may post after vacation, Your Lordship. He is not
Yes.
here. Your Lordship, meaning that Your Lordship pertaining to item 38 also similar fare is there.
It's a family pension, my lord.
when the Sharma will be available.
Wow, good outside.
Next week, Your Lordship, Wednesday or Thursday onwards. Next week.
Wednesday.
He's out of
Can it
station.
be on
Out of station.
Thursday?
He's out of station.
He's out of station.
Thursday.
Thursday.
Or and or
Correspondent number 2.
for you Sharma or
It took 21. Lordship, I'm praying for showing my name in the cause list, Your Lordship. Corresponding.
Election.
Deeply obliged. কিমান আছিলে মোৰ?
Well, in this case, my lord, I am appearing the respondent. I have filed a local, my lord. I have received the instruction. my lord. His name will be placed before the next SLC. my lord.
What is the direction?
Page 23, my lord. In view of the above, we require the Director Elementary Education Department, Government of Assam, to revisit the order dated 12/4/2023 and pass a fresh order after taking into account the observation made by this court in paragraph 4, 5, and 6 of the order dated 25/5/2022, passed in WBC 3305. It is clarified that the the remand for reconsideration for being passed only on account of the fact that the above noted communication dated 21/9/2021 was not taken into account and not on account of the fact that any of the materials relied upon by the said authority for arriving at a conclusion is contained in the order dated
12/4/2020 has been doubted because the said order was not considered on merit, but it was only considered on account of reconsideration of the communication dated 21/09/2021 while passing the said order. The Director Elementary Education Department Government was, after taking into consideration matter already available in record along with the said communication dated 21/9/2021 shall be passed.
Section.
Well, may I please?
With the
SLC, my lord, one of the members is on leave. That is why, my lord, probably after 30, my lord, of this month.
after vacation will leave the matter. But and then today council of the Kora or the for decided that the matter next state level meeting further according it invited that it's the matter of immediately after the meeting the letter for mark the letter and will take to the
Obliged, my lord.
May it be pleases your lordship, I am appearing on behalf of U Sharma. Your lordship, the last instruction, your lordship, is on dated 28/8/2025. Thereafter, your lordship, no latest instruction has been received. So I pray for the same, your lordship. Kindly matter me list on Friday, your lordship. In between, your lordship, I'll try to obtain instruction. As this instruction has already been placed, your lordship, I would like to submit it one. তুমি তোমালোকে দিছিলা ন ফিনান্সৰ মোক দিয়া নাই তো এইটো ফল্ডাৰ আছে Finance has already placed their instruction, your lordship. So I may allow to take the fresh instruction, your lordship, in this regard. Yes, we might have copied. Okay. Maybe better নহয় মই নাপাওঁ ফল্ডাৰ হয় Friday, your lordship. Friday, your lordship. Already some matters has already fixed on Tuesday, so your lordship, Friday one more day, your. Right.
then on Friday
Friday.
or but on that day you also have
Yes, your lordship. I will convey it today itself, your lordship. In this matter, your lordship, U Sharma is appearing, and I'm nowhere in.
Now you tell me who will obtain the instruction.
I am going to obtain instruction. I will convey it.
Cards, or that's consequence that by means.
And Sharma.
Does some instead much of the update status is not available her and not available or obtain for the status of the file. The e-file number is double 58. Friday. Right. Reflecting the name of it. Dust.
Your lordship, I am nowhere in connected as a contemner, your lordship. I have not signed.
That on next day. I
Obliged.
I'm deeply obliged.
My pleasure, Lordship. I am appearing for item number 24, Lordship. My senior is out of station and we made a request to do the matter through video conferencing, Lordship. Now there is some network problem there, Lord. So we only prayed before your Lordship to list the matter again on 18, 19, 19, 18.
After making some time. The agreed by learned advocate of both the parties that the matter on
Immediately after vacation, Lordship. Finish.
23rd of.
give your time.
Yes,
Yes, Lord.
highly obliged.